Words. It's a Tuesday. I've got coffee. I've got Kersey. We have a lot to talk about. Like, a lot has happened since Sunday. Like, a lot has happened. And I was going to talk about some other topics today, but I'm fascinated by this DMCA lawsuit. So we're going to talk about that today too, because sometimes when I'm fascinated, it's just that's the avenue we're going. So what I was going to talk about on Tuesday was prepped last week, and then it all got yeeted right out the window, and we've got an entirely new show for you today. So today in QuickBits, I'm going to be talking about the Supreme Court taking on the Warhol copyright case, which could change the definition of fair use and transformative use, something I'm very interested here on the platform because so much of what creators rely on is fair use. The FTC is going after TurboTax, which will be a quick bit. Then we are going to get into WTF happened at the Oscars from a legal perspective. There is a lot of other context and a lot of ways to talk about this story. I am going to talk about it from the perspective of a former prosecutor and going through the legal sides of it while acknowledging that there is a lot of context here. But does context change the legal analysis of what happened at the Oscars? I've been asked a lot about fighting words. Y'all aren't going to like what I have to say about that, I don't think, but we're going to talk about it anyway because the law's the law, and sometimes facts, just facts. I've got which shirt? I've got my facts shirt on today. We were inspired. And then we're going to talk about this Bungie lawsuit over DMCA trolls and the issue on this platform. So if you're seeing this video, the platform hasn't taken it down yet, but there is actually another lawsuit where a company sued YouTube for not enforcing its policies when people abuse the takedown system. And that is the heart of this Bungie lawsuit too, and where a lot of the criticism has come. So even though it is a video game creator, it really is a lawsuit that goes to the heart of a core issue here on YouTube. And it's going to be very interesting to talk about. I've totally forgotten to share this out on Twitter. So if any of you want to go ahead and do Emily, were you prepared this morning? No, we're always prepared. We're professionals here. Let me know where you're coming in from. I've got my coffee. You've got your Kersey words. I've told you what we're going to get into. Replay crew. I didn't want to give you a half a heart. Love you. I will have timestamps down below at the end of this. Last week was crazy. I had to jump out for an appointment right after the show. And one of the amazing law nerds timestamped it down in the comments. And I was like, oh my God, thank you for getting to it before I could. So I appreciate that. We are going to be going through all the things. So I'm fascinated by this comment. My friend's mom was painted by Warhol. She even has Polaroids of him painting her pic. He was a starving artist and her dad had money. That's fascinating. I wonder how much that is. Amy, when I get to this, I am going to link to Natalie Lawyer Chick's video and send everyone there because she actually pulls in a lot of the other context. We are going to do mostly the legal context, again, while acknowledging that there is other context. So yes, I will be shouting out her video when we get to that and linking it down in the description below. You guys know that I love Natalie Lawyer Chick. I like the way that she addresses things, and I always appreciate her content. So with that, I think Nate the lawyer has a video on it. I haven't had a chance to watch that today. I am sure there will be a Legal Eagle video on this. I am sure tons of people made videos yesterday. I have not had time to get to everything. So there we go. All right. Let us just roll the intro and we should just get into it. Emily, are you looking for your intro? Mm-hmm. Yep, I moved it when I recorded the podcast for the members who were at that live recording of this week's podcast. You know how that went, and I'll tell you that story in just a minute. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the Kersey words. This channel is where the law nerds unite to talk about facts, not fuckery. It's so good to see you guys. It's good to see everybody coming in and saying hello and what you're drinking. Yeah, we're absolutely going to be talking about the Oscars, but we've got to get to quick bits a little bit first. But first, a quick story. For those of you who caught my live yesterday on Instagram, I have been having some tech troubles. It's just, again, we've got to get things set up. We've got to get things set up with a new computer because I wanted to be able to travel a bit more and be able, well, I've got to travel a bit more. There's lots of travel that's going to be happening. And I wanted to be able to still stream from the road. I didn't want to have to make the choice of if I travel, streaming is going to be hard and I'm going to be on the iPad. I love that I can stream from the iPad Pro. I love that that's an option. For what I do, it is not the best option because I can't pull up documents well or easily, and it is such a hassle. So I really prefer to be able to do it from a computer. I didn't have a laptop, got a new laptop, decided to make it my main computer for everything, and have had nothing but setup quirks because we're trying to figure out the setup. So while I was trying to record my podcast for this week that comes out tomorrow, and if you aren't subscribed to the Emily Show on your favorite podcasting app, maybe just go ahead and you can go ahead and do that. But the video always comes out here after that. So if you're subscribed here, you get the video episodes of the Emily Show. I was trying to record and I had nothing but camera freeze issues, like so many camera freeze issues, like me trying to talk and being like, camera freeze issues. And with the camera freeze issues, I got so frustrated and I was redoing all of the inputs into my computer. Once I get this set up the way I want, I will do a video on my channel that's totally out of character for what I normally cover of how I made my streaming setup work, because I know there's a lot of content creators that can use that information. Gosh, I sure could have. I've hodgepodged it together the best way I can, dealing with the camera I already have, chip shortages, preventing a new camera, and things like that. So the setup took a bit. So Sunday night, I was completely just sucked into getting this podcast out. I needed to get it to my editors to give them enough time, and I didn't want them to be time crunched. It's also a long episode because we're going over the Sherry Papini criminal complaint. So that is a 55-page criminal complaint. It's quite extensive. So it's a long episode to boot. By the time I got done and went out to see the doc and my kiddo who wasn't asleep, I was like, okay, okay, what is happening? And they're both like, dude, you're not going to believe what happened. And so they rewound the telecast for me so that I could see what happened at the Oscars. And I was like, no way, no way this is what's happened. And so we rewound a couple times to try to figure out the same thing everyone else on the internet tried to figure out. Is this staged? Is this this? Is this that? And it was wild. And then I opened my phone and went onto the internet, and the conversations were wild. I shared some of them on Twitter, some of the things people were saying about it, just to be like, this is the conversation that's being had in a thread. Some of those Judd Apatow's tweets since deleted, which I completely understand, but seeing people's live reactions to it on social media was very interesting to me. I was, again, well, I'll get into it when we get into the case. I was surprised how everyone reacted in the moment, but we'll talk about reactions in the moment soon when we get into it. So that's kind of how that went down for me on Sunday. And then I ended up being up way too late on Sunday, dealing with the not just the podcast episode, but also I was up looking at what people were saying and was very interested in the conversation as it was going down online. It's always fascinating to me to see how one thing is not just interpreted different, perceived different, received different, how it's talked about differently, and how different parts of the context matter more, depending on our own context for things. And that was very, very interesting to me. So I'm always fascinated by the conversations going on online. You know that. This is what I love about pop culture. Pop culture are things that we all want to talk about. And that is one of the things I love the most about pop culture. So I am going to go and share this out onto the great wide interwebs because I totally forgot to share it on Twitter. And we will get in.
Could you say that again? I'm having trouble hearing you.
I don't. All of the tech wants to talk to me all of the time. And I just, I don't know why. All of the tech wants to talk to me, and I don't know why. All of the tech, all of the time. And that happened while I was recording the podcast too, which may or may not make it into a blooper. We will see. So, with that, I'm going to take a deep breath and we are going to get to QuickBits. I should roll the QuickBits bumper. Did you know I have a QuickBits channel? There's now a QuickBits channel. It is linked in the description. I don't remember if I've added Nightbot to share it. The mods can share it. Hello, Mod Squad. Good to see you. But there is now a QuickBits channel that has shorter, cleaned up versions of the topics we talk about in the live videos in specific chunks, and then my YouTube shorts that are, the 1 minute quick, like, this is what happened. The reason I didn't do a YouTube short on the Oscars is because I really wanted some time to think on it, process it, and decide how it's helpful for me to address it given my life and experience. And we're going to just address it from the legal side because that's the best way I can address it. So with that, we're going to roll the quick bits. We're going to share this on Twitter and we're going to do the things. Quick bits. Quick bits. So just a plug for the Quick Bits channel. If you want, sometimes you miss or cannot watch an entire stream. I totally get it. To be able to have somewhere to be like, oh, this is what it is without sometimes the tangents or interpolations. I've cut that down to try to bring in just the topic. And I think that will be helpful for some, and others are just like, no, we're here for the tangents and the whole thing. We are here for everything. With that, let us get to today's quick bits. First, we are going to talk about the Supreme Court. The Supreme Court just approved a number of cases. We're only going to talk about this one today. Will we talk about others in the future? Maybe. I tend not to cover the Supreme Court too carefully until they rule on something, but I wanted to bring up that this is coming up because we do talk a lot about intellectual property and copyright on this channel. It matters, and I love these conversations. We will be covering music copyright again soon. I've got a whole music copyright episode we need to do. It's just timing is everything. My cats right now, y'all, there is a little moth right outside my window that's on the window that is fluttering and will not leave the window. So the Ponards are very much on high alert today. They're on high alert with that. So let's talk real quick. And I'm bringing up two stories to talk about this. This first one comes from Law 360 because they actually shared the image. They're the only ones that did. So is screen share ready, Emily? No, we're professionals here. Why would screen share be ready? Why would screen share be ready? I don't need my alerts popping up. All right, this is the image that we're talking about. This image of Prince, the original one being a photograph taken, the second being a Warhol taken, a Warhol painted. So the Supreme Court on Monday agreed to literally yesterday. So much has happened on Sunday that some of this stuff got missed. This happened literally yesterday. The Supreme Court agreed Monday to review the Second Circuit's decision that Andy Warhol's artwork did not make fair use of a photo of music legend Prince, following a petition that argued that the High Court needs to clarify a circuit split on what makes works transformative. Here's the thing. This is generally the province of the Supreme Court, clearing up splits in the circuits. So when we look at the federal court system, you've got state courts and then you've got federal courts kind of, it's hard to say, overlaying the system. The US is divided into circuits, with the First Circuit starting on the East Coast and the Ninth Circuit on the West Coast, including Hawaii. So you've got different circuits that decide cases, and the circuit decision decides for that entire region of federal courts versus the state system where you have the state court, the state appeals court, and then the state Supreme Court. So in the federal system, you have federal courts in different states governed by a circuit, and then the circuits are governed by the Supreme Court, and the Supremes are the law of the land, so the state courts have to impose that law too. but the states also have their own Supreme Court. So for all of you internationally going, what is happening? We have a lot of courts in the US. When you feel like there's a lot of lawyers in the US, there's also a lot of courts in the US. There is federal practice and state practice, and sometimes they overlap and sometimes they don't. There's a lot of courts in the US. So when the circuits are deciding things differently, it can get very confusing for the circuits to resolve things and for the lawyers and for, all of us. Like, well, in the Second Circuit, it's this, but in the Ninth Circuit, it's that. So when there is a split in the circuits, the Supreme Court will often take up the issue and try to resolve the split and say, y'all, this is what it is. Go forth and use this standard going forward. So with that, we have a circuit split with regard to the fair use and transformative work. This pulls us into and harkens back to Kat Von D tattooing a photograph taken by a professional and famous photographer. Is just tattooing someone else's photo on skin transformative? Is just changing the colors of a photo like this transformative? Is taking a photo that the paparazzi took and throwing it on a shirt and selling it transformative? Jen Shaw. No. I closed my coffee and went to drink it. I'm sure you all saw that. That's embarrassing. So in its order list, the High Court granted the Warhol Foundation's petition challenging the Second Circuit's ruling that Warhol's work was not transformative. So the Second Circuit said, negative, ghostwriter, the pattern is full. You have to pay the original photographer. This was not transformative. This is not fair use. This is copyright infringement. So the Second Circuit found that Warhol's work was not transformative fair use of a copyrighted photograph of Prince by Lynn Goldsmith. Warhol's work retained the, quote, essential elements of its source material and was not fundamentally different and new, the appeals court said. You guys get to decide for yourselves, but when you look at the fundamental elements and try to determine what are the fundamental elements of art, it can be challenging. This is me knocking into my mic that knocks into my camera. This is something that we cover on YouTube when it comes to restreaming a trial, a law and crime, and giving commentary over it. That makes something new and different. If it is commentary over the entire thing, it changes the source work. If you want more discussion about fair use, transformative works, there is a breakdown on this channel of Haas versus Klein about what is and what is not fair use and transformative use when giving commentary over a video. And we will continue to talk about fair use in other copyrights that come up. This is going to come up more and more and more in the Wild West that is the internet. So the Second Circuit found that this Warhol is copyright infringement of this photo. The Warhol Foundation has then appealed to the Supreme Court, and the Supreme Court said, you know what? We will address this. There is a split in the circuits, and we need to figure out what this is. But again, defining art is difficult. And I know I'm in a tangent. I know a lot of it was very split during the last Supreme Court nominations, but Judge Brown, or the Honorable Judge Brown, was asked whether or what the definition was of a woman. And the judge was like, this is not a definition I can give. The job of a judge is to look at the things and determine these definitions in context, because context matters. And there were a lot of people who were like, well, why wouldn't she define it? Why wouldn't she not? And I understand, looking at it in the purview of a judge, defining things, the context of the case in front of you matters for a legal definition. We're not talking about a colloquial definition working in society. We are talking about legal definitions. So with legal definitions, what is fundamentally indifferent is new, and what are essential elements? How do you describe what essential elements of an artwork are? What are the essential elements of a piece of music? I mean, Ed Sheeran is still waiting on a jury verdict over, I think it's Piece of You. Oh, it is. It's Judge Brown Jackson. It is Judge Jackson. You are correct. I am Judge Brown Jackson. I am incorrect. And I, two last names and I conflated them. Apologies. And I also try not to sing because every time I say Judge Jackson, I think of, sorry, Miss Jackson. So, essential elements, definitions. Definitions matter, but definitions for the legal sense matter in context and the context of the case. And normally when it comes up, the Supreme Court has, well, this circuit is saying it's this, and this circuit is saying is this. And then they figure out a definition given history and case law and stare decisis and all of the things. And then they decide what the definition is. What is the definition of is? Legal. This is legal. Fighting over the definitions of words is like one of the core and fundamental elements of being an attorney. So, going forward, where was I? The appeals court found that the second work, the Warhol, was not fundamentally different and new. But in forbidding courts from determining the intent or meaning of the works at issue, the Supreme Court's approach conflicts with the High Court's precedent, including the April 2021 ruling in Google versus Oracle, which was over copyright of code, which the foundation says repeatedly made clear that a work is transformative if it conveys a different meaning or message from the source material. And again, do these two convey different meanings and message? The ruling also conflicted with the Ninth Circuit's test for determining transformative use, it said. And the Ninth Circuit is where California sits and where the Taylor Swift Shake It Off copyright suit is pending. So with that, the attorney from Latham and Watkins said for the Warhol Foundation said, "We welcome the court's decision to grant review. This case raises fundamental issues of copyright law and free artistic expression, and we look forward to presenting our arguments to the court." This is going to impact everything from like the Nike Satan shoes context, where you have a shoe remade into something else, where you have parody works, where you have somebody painting a Birkin bag in a different context, but all. So this will be an important ruling. I am interested to see what they do. And let's see. In talking still about this Warhol in particular, a New York federal judge ruled in 2019 that Warhol transformed the image from a vulnerable, uncomfortable person into an iconic, larger-than-life figure. But the Second Circuit said in March 2021 that the district judge's decision had placed too much emphasis on subjective meaning. And this is the thing, though. These are all subjective tests. It's why when I talk about copyright for creators and they're like, but it's fair use, it's like, but you have to prove that to a judge. And you have to hope that that judge is not like on a new diet or going through a divorce or had a kid just move back home or something else in their life that has made them cranky or joyful, and that this judge is on your side. So with that, these are subjective tests where the court has to look at factors that are kind of, what is transformed anyway, and make these decisions. And it goes case by case. So when creators rely on, but it's fair use, it's like, but how much money are you going to spend to prove that? You better make it clear fair use. And the intent of copyright is to protect artistic expression. But when does protecting the artistic expression of the photograph impede the artistic expression of the silkscreen or painting? And I don't remember which this Warhol is. Where do the rights bump up against each other? And whose rights are superior to the other rights? Is it the original artist? Is it the transformative artist? Where is the protection of original work? And then how will this all transmute onto platforms like, TikTok, where copying someone's choreography is basically a giant, a huge part of that platform. But what about the original choreographer not getting credited? And what if somebody gets to be on a late night show performing somebody else's choreography and doesn't give credit, but then gets paid for it? Then is that copyright infringement too? Because our dance can be copyright, choreography can be copyrighted. It's just my little lawyer brain is like, there's so much here. There's so much here. And then it's when we look at music copyright cases, there's also but how there's only so many chords and there's only so many ways to arrange them. And in music, a lot of the time you give people the writing credit and they get paid or licensed, and then it's fine. I think we'll see that in choreography too. So with that, in August, the Second Circuit amended its opinion to account for the Google ruling in April, but still found that Warhol had not made fair use of the image. If you guys want a deep dive of Prince's face, and I love Prince, so I'm always here to deep dive Prince's face and the copyright pertaining thereto. I will go through the Second Circuit decision. I will probably do that when the Supreme Court rules on this and break down both. I normally do questions at the end, but this was a question that absolutely caught my eye and I love. Could this devalue Warhol's work? I don't think so. I think it means the source artist has the opportunity to say, this work, you sold it for this much, you licensed it, whatever, I get paid for that because you infringed. This is more about money. I don't think it'll devalue Warhol's work. Will it open a can of worms or a can of Campbell's soup with Warhol's work? Maybe it will. But I am interested to see what the Supremes do with this. I enjoy talking about the Supreme Court making decisions that actually will impact all of our lives, especially when they are in the realm of things like copyright that impact creatives and creators and artists. It's just very interesting. And it's polarizing in a different way than when the Supremes decide things like elections, which are so polarizing, I half the time just don't want to talk about it. So thank you, Ryan Miller, for getting my joke. I'm interested to see where this goes. I wanted to talk real quick about the Google Oracle case that they are referring to because I thought it was fascinating. I hadn't covered that much. But it's going to factor into future analyses. So I'm going to pull up this Reuters article real quick because it talks a little bit about the Google Oracle case. It's so interesting, the copyright, when you think of things like code versus patents or trademarks with regard to code. Rachel asked a great question that I didn't address. The Warhol Foundation brought the lawsuit to seek a determination that this wasn't copyright violation after the original photographer learned of the use. And the Reuters article talks about it a little bit. So we're going to get into that article now, and I will link this down below. In a case that can help clarify when and how artists can make use of the work of others, the U.S. Supreme Court Monday agreed to decide a copyright dispute between a photographer and Andy Warhol's estate over Warhol's 1984 paintings of rock star Prince. The justices took up the Andy Warhol Foundation's appeal of the lower court ruling that his paintings based on a photo of Prince that photographer Lynn Goldsmith had shot for Newsweek magazine in 1981 were not protected by the copyright law doctrine called fair use. The doctrine permits unlicensed use of copyright protected works under certain circumstances, including transformative use, parody, etc. Goldsmith 74 countersued Warhol's estate for infringement in 2017. So the Warhol Foundation sued to determine that it was not copyright infringement. The photographer countersued in 2017 over the 1984 work of art. Let's see. I lose my place. Sorry, countersued for copyright infringement in 2017 over Warhol's unlicensed painting of Prince after the estate asked a Manhattan federal court to find that his works did not violate her rights. Warhol, who died in 1987, often based his art on photographs. Thus, we know. Goldsmith, who said she did not learn about the unlicensed work until after Prince passed in 2016 asked the court to block Warhol's estate from making further use of her work and for an unspecified amount of money damages, because civil suit, money. The judge ruled that Warhol's works were protected against Goldsmith's infringement claims by the fair use doctrine. That's the first court. Finding that they transformed the portrait of Prince as a vulnerable human being by depicting him as an iconic, larger-than-life figure. After Goldsmith challenged the decision, appealed it, the New York-based Second Circuit Court of Appeals late last year found that Warhol's paintings had not made fair use of the photo, allowing the case to proceed. The Second Circuit decided that a transformative work must have a, quote, fundamentally different and new artistic purpose and character. Is color a character? I feel like color in art is a big character, but okay. Also, it's so interesting to me. A lot of lawyers are not artistic and creative. So it's interesting having a bunch of judges decide what art is. It's just so interesting. It's just so interesting. And they say that Warhol's paintings were much closer to presenting the same work in a different form. Again, like the Kat Von D photograph tattooed. Same work, different form, not enough. The Andy Warhol Foundation asked the Supreme Court in December to overturn the Second Circuit decision, arguing that it created a cloud of legal uncertainty, a circuit split, for an entire genre of art like Warhol's. I mean, and things like, Mischief, who make transformative works of existing physical items most of the time. Warhol Foundation attorney Roman Martinez said he welcomed the High Court's decision to hear the case and hopes it will recognize that Andy Warhol's transformative works of art are fully protected by law. Goldsmith said in a statement provided by one of her lawyers that she looked forward to continuing her legal fight at the Supreme Court. Quote, 5 years ago, the foundation sued me to obtain a ruling that it could use my photograph without asking my permission or paying me anything for my work. I fought this suit to protect not only my rights, but the rights of all photographers and visual artists who make a living by licensing their creative work. And also to decide when and how and even whether to exploit their creative works or license others to do so, Goldsmith said. The Supreme Court addressed an issue of copyright fair use last year in a ruling finding that the use of Oracle's software code by Alphabet Inc.'s Google in its Android operating system was protected. In 1994 Supreme Court ruling on fair use involving artistic creation, the justices found that a rap group, Two Live Crew's parody of Roy Orbison's Oh Pretty Woman made fair use of Orbison's song. By the way, I love both of those songs. So, what is art? I know it when I see it. How do you define it? What's transformative use? And we get to talk about Prince. I love everything about this. I look forward to the Supremes taking it on. We're going to get deeply legal when they decide this, because we're going to go through what the Second Circuit said and then what they say here. But today was just a quick bit, and this was a longer quick bit than I had intended, but it was a quick bit. So let's talk about what TurboTax is up to and why they are in trouble with the FTC, not the FCC, but the FTC. Not the FCC won't let me be or let me be me on MTV. Not that. The Federal Trade Commission. The FTC is going after TurboTax. Let's go to the statement from Intuit, the parent company of TurboTax, first, and then we will go to what is happening here. Why can I not make here? Cats. The Pawnards are getting so feisty. You can't fight with each other on my desk while I'm recording. Separate. Fred is stuck. Separate. Everyone separate. Look, if you're a streamer, dogs are one thing. They can be loud on stream, but cats can cause all manner of other chaos. So, Fred's going to get DEFCON Fredded in a second here. Chaos, but that was both of them causing chaos. All right, let's talk about, I wish I could hide this so much, but I can't. Let's see. Oh my God, why Intuit, why have you coded your website so that this is so close to the text? So annoying. Intuit responds to complaint from U.S. Federal Trade Commission, March 28, 2022, Mountain View, California. Intuit, a global technology platform that makes TurboTax, QuickBooks, Mint, Credit Karma, and MailChimp. I didn't know Intuit made MailChimp. I had no idea. You learn something new every day. Announced that it will vigorously challenge a complaint filed today in the U.S. District Court in the Northern District of California by the U.S. FTC. And it's filing, the FTC inaccurately, again, this is Intuit's statement, inaccurately alleges Intuit's advertising practices directed consumers who were eligible for free tax filing software from TurboTax or the IRS free file program to the company's paid tax preparation products. They say the facts say otherwise. Quote, the FTC's arguments are simply not credible. Far from steering taxpayers away from the free tax preparation offerings, our free advertising campaigns have led to more Americans filing their taxes for free than ever before and have been central to raising awareness of free tax prep, says Carrie McLean, Executive Vice President and General Counsel of Intuit. General Counsel means the lawyer. The lawyer, well, probably one of a fleet of lawyers at Intuit, but still. Over the past 8 years, TurboTax products have helped nearly 100 million Americans file their taxes for free, and our most recent free advertising campaign has only accelerated the use of TurboTax free offerings, driving approximately 60% of growth from 11 million free filers in 2018 before the campaign launch to more than 17 million free filers in 2021. U.S. law nerds, have you all seen the TurboTax free advertisements? I mean, it is getting to be tax time. If our taxes weren't so fucking complicated, maybe all of this wouldn't be an issue. I always resonate so deeply with the memes of like, are you going to tell me how much I owe in taxes? No. So I have to guess? Yes. What happens if I get it wrong? Jail. Our tax system in the US is such a deeply complicated tax system that it has spawned a $1 billion+ industry to help people figure out what the fuck they need to pay. It also creates quite a lot of loopholes and exceptions for those who can use the system to their benefit. Generally, you need to be wealthy to use the system for your benefit. It is just, I could rant about the tax code being manipulation of behavior all day long. You've heard me go on about it certain times. You know how I feel about the behavior control in the tax code, the behavior control for the tax code. You know how I feel about it. Manipulation. It's like, oh, the SUV lobby wants you to buy SUVs. Let's give a tax credit for a certain weight class of car. All right. I studied tax a lot in law school because I was fascinated by how it was leveraged. I was going to finish tangenting and then I didn't. I was so fascinated in how it was leveraged and the way that our government uses tax as like, look, I'm doing something for my constituents. I got you this tax break. I got this industry, this tax incentive. Our tax code is used as a football back and forth in political infighting. So our tax code ends up being this long, full of all kinds of different wandering loopholes. It's behavior control. Anyway, I will get back to the FTC won't let me be. It's the FCC won't let me be or let me be. Sorry, I can't. 90s. They say, quote, the fact that Intuit complied with the rules and regulations of one government agency, but is now being targeted by another. Oh, wait, here we go. I need to back up. In fact, Intuit has always supported consumers filing for free as a founding member of the IRS free file program and in our other practices. The FTC's complaint fails to acknowledge the reality that Intuit was at all times in compliance with the IRS requirements. Yes, well, the IRS doesn't regulate the way that you advertise. See, it's so funny how bureaucracy works. The FTC regulates how you talk about things. The IRS just regulates your taxes. They go on to say the fact that Intuit complied with the rules and regulations of one government agency, but is now being targeted by another demonstrates a significant disconnect. Well, with the FTC's action, companies will be much less willing to enter into public-private partnerships with the government that benefit consumers. Well, it's really about it's really about the way that you advertise. I don't know if it has much to do with your work with the IRS. So, Intuit continually sought and continues to seek ways to increase the number of taxpayers that file using its free tax preparation products. Last tax season alone, Intuit delivered 17 million free tax filings, the most in the industry. Intuit helped the IRS Free File organization far exceed its stated goals of making free tax preparation available to 70% of filers. Today, free tax preparation is currently available to 100% of American taxpayers. That program, created and governed by the IRS, established marketing requirements for all participants. Oh, well, that's new information. The IRS creating marketing regulations. I wonder if they chatted with the FTC about it. I'm going to guess no. But that's a guess. So if the IRS created marketing regulations, the FTC going after people is going to be real interesting. As a longtime advocate for tax simplification, same. The taxpayer access to free tax preparation, the facts of this case do not support the FTC's claims. While it is disproportioning, that says disappointing. While it is disappointing that the FTC chose to file this lawsuit, we look forward to presenting the facts, not the fuckery, in court and are confident in the merits of our position, McLean said. In its decision to file a claim against Intuit, the FTC commissioners were not unanimous. So, what is the FTC saying real quick before we move on to talking about the Oscars? The FTC says that TurboTax is lying, baby, why you lying, is lying about its services being free. We will go over the complaint another day if it really matters to anybody, but the Federal Trade Commission, on Monday, asked a California federal court to block Intuit's TurboTax from marketing its tax filing products as free, claiming that the company is being deceptive and often doesn't actually allow consumers to file for free using its services. The FTC filed a complaint against Intuit, TurboTax parent company, as well as a motion for a temporary restraining order. We've seen lots of TROs lately. The temporary restraining order will stop them from doing a certain thing, or in this case, marketing a certain thing. Unless the court steps in, Intuit will, quote, be free to continue disseminating the deceptive claim that consumers can file their taxes for free using TurboTax, when in truth, in numerous instances, defendant does not permit consumers to file their taxes for free using TurboTax. I imagine that there are some circumstances where someone goes in to use the free filing and doesn't qualify. I have to know, because this happens all the time. If you are watching this on the replay and you get TurboTax ads on this video because I've said it so many times, will you please just let me know in the comments? Because I'm fascinated how that works. It happens all the time, but I'm fascinated. So I'm just fascinated. I imagine what happens is that there are consumers that qualify for free under the IRS free filing, but many that don't. But free is free. Free means you charge nothing. The FTC noted that it has filed an administrative law complaint as well, and a hearing will determine whether Intuit's representatives violated the law. According to the FTC's suit, Intuit's advertising for TurboTax largely centers on the message that consumers can file their taxes for free using TurboTax. The agency pointed to TurboTax commercials in which every word uttered is purportedly the word free. Okay. In truth, TurboTax is only free for some users based on the tax forms they need. I imagine that that's actually accurate and completely accurate. For many others, Intuit tells them, after they've invested time and effort of gathering and inputting into TurboTax their sensitive personal and financial information to prepare their tax returns, that they cannot continue for free and they will need to upgrade to a paid TurboTax service to complete and file their taxes. So they're alleging that this is somewhat of a bait and switch. The FTC accused California-based Intuit of engaging in deceptive business practices and in its marketing, distribution, and sale of TurboTax. We need more coffee. Specifically, the FTC pointed to Intuit's Absolute Zero ad campaign, in which it told consumers that its offering was truly free, according to the complaint. The agency said Intuit's campaign included the words free guaranteed. Oh, what we can't do is guarantee something that you can't guarantee. I wonder is there an asterisk? We need an asterisk. Free guaranteed unless you don't qualify. Free for some, it's not going to be free for all. You guys in the chat are like, yeah, that shit's not free. Include the words free guaranteed to bolster and emphasize the claim that the offer was truly free. There's also the Intuit free. Mike. Free campaign, the FTC said. In those commercials, actors mostly say the word free over and over. It said some of those ads feature the word free more than 40 times over the span of 30 seconds. Did they do a Super Bowl ad? A free Super Bowl ad? Where am I remembering it from? I don't see a lot of ads because I watch a lot of YouTube and I have YouTube Premium. But I try to avoid ads. But I haven't. Did I see that on the Super Bowl? I don't remember. While the ads do contain a fine print disclaimer, this is what we're going to fight over, clarifying that the offer is limited to consumers with simple tax returns, this is inadequate to cure the misrepresentation that consumers can file their taxes for free, the FTC said. That's because the disclaimers are too small, appear for just seconds, and are in writing only and not read by voiceover per the complaint. You've all seen and heard commercials where you get the legal voice at the end going, this offer is not 100% free. This is me ad-libbing. This offer is not 100% free for all customers. Only some customers will qualify for this being 100% free. You have to file simple tax forms within this date and this date between the hours of 10 a.m. and 12 p.m. for this offer to truly be free. You've all heard that at the end of commercials. You've all seen it at the end of commercials for offers, for giveaways, for medications. So the fact that they are saying that there was no voiceover is going to be a problem because that is required. Yes, Cassie Walters said, side effects may include everything, including death. Your taxes may actually not be free. It depends on the form that you need. The 1040 easy is free. Everything else, no. On top of that, what simple means to TurboTax has changed over time, the agency alleged, and many low and middle income consumers that paid into it to upgrade to a paid version of TurboTax have been eligible to prepare and file their taxes electronically at no cost through the IRS Free File program. Until 2021, when Intuit left. Oh, that's interesting. That's interesting considering that TurboTax relied on talking about the free program. Until 2021, when Intuit left the IRS Free File program, the Free File version of TurboTax provided an online solution for all IRS tax forms, regardless of the consumer's source or types of income or the variety of their deductions and tax credits, so long as consumers fell within the prescribed adjusted gross income threshold that Intuit set each year, the agency said. The only other versions of TurboTax that would have provided equal coverage for all tax situation and tax forms is its most expensive paid version of TurboTax Self-Employed. Self-employed taxes are a bitch and a half. The FTC said it was likely to succeed in proving that Intuit's advertisements were deceptive, that no voiceover is going to hurt them, and the consumers are suffering and will continue to suffer substantial injury. Here's the thing. When you get people to go through the process of getting everything input, if most people, by the time they get to the end, if it's like, oh, you've got to pay to upgrade, most people are going to go, fucking fine. I'm already here, fine. And they're alleging that Intuit knows that and is relying on that. That's why you're seeing the deceptive trade practices. So I think this will be interesting to follow too. The FTC gets real sassy, and they're just not having it. I wonder if they'll get a TRO and we will see the ads come down. It will be very interesting to see. So taxes in the US are the worst. I mean, the complexity that is baked into the system does not support the consumers. It never goes well for them. That said, if you want your taxes to be better, having your own company absolutely helps. Let us move on to the Oscars. Let us just move on to the Oscars. I'm gonna swoopy swoop. Miss H, this caught my eye. I normally get to the super chats at the end, but this was right on topic as I'm getting ready to swoop. Miss H said, I use TurboTax. It is free if they print and mail it themselves. My youngest daughter was free since she mailed it. She had to print it out and mail it. If you send electronically, you have to pay out of pocket. Interesting, TurboTax. Rihanna said, my blood is boiling. Emily is 100% right. TurboTax relies on people being exhausted by the end of their process. I've been a victim of that by them. It really does rely on the fact that by the time you get to this is what it seems they're alleging. from the FTC. By the time you get to the end, you're exhausted and you're like, you've already sunk in time, and that sunk time cost matters. And especially if you are someone who is neurodivergent like me, the amount of actual energy and time it takes to gather the information, to force yourself to sit down and do it, to put it all into the forms. By the time you're done, if you don't pay for it, you're just going to be like, screw it, I'll pay my taxes in 3 years. It's a lot of energy. And for people who are working multiple jobs, and taxes are such a hassle, and people can be so highly avoidant, and so playing on that is tough for me, and there are so many that struggle with it. So Yamino Games said the spoons used is awful for taxes. It really is. It is such, I need multiple forms of help with taxes. It's one of those things that is very, very difficult for me, even though I don't mind doing taxes. It's all the executive functioning that's required that is hard for the ADHD souls. We're not the only ones that it's hard to, but I can only speak to my experience. So, and then the fear, also dyslexic, of entering things in wrong and having that be a huge issue. I'll tell you the story another time about me entering in my payment wrong one year, and just what a mess it created because I inverted numbers. It was just, this is why I pay someone to do this, because I am afraid that even when I go to pay, I will enter in the numbers wrong because I have done it in the past. And I don't like paying fines for a mistake based on my brain. All right, let's talk about the Oscars. Will Smith and Chris Rock at the Oscars. I'm sure all of you have seen it or seen it on social media. I have the unedited version in a thread of conversation about this on Twitter if you want to see the unedited version. I am going to cover this from the legal perspective and talk about the legal implications here and the way that things like what's posted on social media can play out in prosecutions from the perspective of a prosecutor. I'm a former prosecutor. I had over 10 years as a district attorney in Los Angeles. So I've worked at courthouses that cover the area where the Oscars went down. How this is going to be addressed and my perspective of how this is going to be addressed is what I'm going with. There is a lot of cultural and contextual issues around this slap that I am for sure not one to address and can't address well. Natalie Lawyer Chick has addressed that on her channel and has talked about not just alopecia, but the making fun of Jada Pinkett Smith's hair when she has an autoimmune disease, when she also is a Black woman, when there are very deeply ingrained cultural significance around hair, and why this was punching down on multiple levels, even if Chris Rock didn't know that it was not an okay joke to make. And not an okay joke to make doesn't necessarily excuse somebody getting hit in the face, but we will talk about the legal side of that. But Natalie's video is great. I will link it here. If one of the mods wants to grab a link and link it in the chat, please do. Welcome to add that, because Natalie gives a lot of context that I could not give. She is a Black woman. That's never been my life experience. I am translucent. So with that, I'm going to cover the legal side of this, not the other implications. Here's where I'm at with watching it go down. This is how I saw it go down, and then we'll get into the law. When I watched it go down, you see them pan to Will Smith and he's laughing, and I see so many people saying, oh, well, he was initially laughing. Here's the thing. He could have still been laughing at the previous joke, because when it pans back up to Chris Rock says, oh, that was a light one. And I think Chris Rock is addressing the reaction he's seeing from Will and Jada. Because when you see, Chris Rock makes the joke, it pans to Will and Jada, you see Jada's face, and she's like, her face says to me, come the fuck on, man. What is this? What is this? What is this? And then you see Will Smith kind of laughing. Will could have been laughing from the previous joke as he was processing what was being said. I'm not saying that Will was still laughing at Chris's joke. I'm not saying that somebody can't initially laugh when they're uncomfortable and then they respond differently. A lot of us respond with either freezing or uncomfortable laughter when uncomfortable things happen to us. That has been my experience. So with that, I think what we saw when people are like, well, he was initially laughing, I don't think that that is the whole context, because then when they panned back to Chris Rock, he's like, that was an okay one, or that was a mild one, or that was a light one. So with him saying that, I think he's reacting to whatever he sees going on with Will Smith and Jada. And I don't know what went on there. We didn't hear it. I don't know if it was a facial response or if it was like a what the fuck gesture. Don't know. But I think that he was responding to that. Before Will Smith takes the stage, walks right up to Chris Rock, smacks him across the face, walks back to his seat, sits down, and then starts yelling at Chris Rock. Chris Rock, though, said, wow, Will Smith just slapped the shit out of me. And then Will responds with, keep my wife's name out of your fucking mouth, twice. And again, you can see that on the aired in Japan video that has a voiceover but does not cut when the curse words are cut. Now, the FCC requires live TV on a delay because they will fine you if those things happen in live TV. They might still hear, because you could see exactly what Will Smith said. I don't know what the FCC will do with that, because they did cut the audio before it aired that Chris Rock said shit. So the FCC is the reason that the audio got cut before Chris Rock said shit. So Will Smith sits down, and then the Oscars go on. You know, the best documentary award is given out. Will Smith goes on to win an award, has a very emotional speech about it. There were parts of that speech that troubled me from my perspective when he's saying love makes you do crazy things. I've seen that said in way too many cases where people excuse acting violently based on like, well, you made me do it. And that's part of what bothered me about the internet's split reaction with this, because I can understand that people are like, I understand why Will Smith did this. You can understand why he did this and empathize with him all day long. But saying what Chris Rock said warranted getting hit goes down kind of a slippery slope for me of, see, you made me do it. But that's based on my experience prosecuting cases where it's like, they made me. You made me hit you. See what happens? Love makes you do crazy things. And that's what's hard for me watching it play out. Because I think there is room for two things. There is room to be like, that joke was not it. And there's also room to be like, and I understand why Will Smith was upset, but I also don't understand getting up on an awards show and smacking someone in the face. I understand yelling from the audience. I understand. So there's room for both. That joke was not okay. But also the response to the joke, while some might say, I understand why he reacted, not okay either. I was surprised that the Oscars or the Academy or the producers of the show did not take Will Smith and escort him at least backstage and take a minute to assess the situation. I imagine everybody was trying to figure out what to do without making the situation bigger than it was. I hope they checked in with Chris Rock. It seems that they did. The Academy has since said that they do not condone violence and they are opening an investigation. The LAPD has issued a statement saying that Chris Rock declines to press charges. And we're going to talk about what pressing charges looks like. At the end of the day, I was stunned, I was sad, and I was stunned. I mean, how do we address where the bounds of comedy are and what's not okay, and how people should know that? I mean, we've also seen Chris Rock recently sharing about his own neurodivergence. And so there's a lot of context here. If this had been in different context, if this had been at a Christmas party, the employer probably would have dealt with it. If this had been at a concert, both people would have been escorted out. If this had been, in different contexts, different things would have happened. It's staggering that it happened at the Academy Awards on live television. It's staggering. It's staggering. So I think nobody really knew how to respond. I think people still don't know how to respond. I think that this is going to have to be responded to by the parties involved in the Academy. I think that's the appropriate form for it. Could this go into a criminally legal form? Yes. Could this go into a civilly legal form? Yes. Do I think that will happen? No. Personally, do I think that should happen? No. I think that this can absolutely be sorted between the individuals. And it's clear that Will Smith snapped. It doesn't mean that that kind of snap is okay. Um, would we be having this same conversation if he had stood up and screamed at stage, "Keep my wife's name out of your mouth"? No, because people would have been like, he stood up for his wife. The joke was a low blow. I understand. That would have been the conversation. But once you get to going hands-on with people, we've ended up in some like alternative housewives reality of table flipping that we don't expect to see at the Academy Awards. I am still surprised that Will Smith, when I say escorted out, wasn't removed at least to backstage for at least a segment of the show to allow the next awards to happen. I feel really bad for all of the amazing things that happened at the Academy Awards, that everything is going to be clouded by this. Everything's going to be clouded by this. It's just it's not okay. So, joke not being okay. Yes. Slapping somebody in the face as a response not being okay? Yes. So let's talk about the legal side of it now that I've given you some of my thoughts on it, because there is a legal side to this whenever you have somebody getting hit by somebody. And the internet, the lawyers on the internet. Hi, I'm a lawyer on the internet. The lawyers on the internet are talking about the differences between assault and battery. Shall we just go to the book for the deep down legal implications of assault and battery? I feel like it's time that we have a discussion about the difference between assault and battery, because then when we talk about the fact that these terms get conflated into state laws, at least we're all on the same page, right? At least we're all on the same page. So let us go to Black's Law Dictionary and talk about it. Let's just assault, criminal and tort law. Here's the thing. Assault can be gone after in the criminal context and the civil context. We will talk about both criminal and civil. So with that, assault. From Black's Law Dictionary, 7th edition, but these definitions don't get updated. The threat or use of force on another. The threat is the thing. It's the imminent touching. The threat or use of force on another that causes that person to have a reasonable apprehension. Those are your buzzwords for your law school exam. Reasonable apprehension of imminent harm or offensive contact. The act of putting another person in reasonable fear or apprehension of an imminent battery by means of an act amounting to an attempt or threat to commit battery. So the assault is the hands up coming towards your face. That is the assault. The hands up coming towards your face. That's the assault. The imminent action, because the result of the assault, here's the result of the assault. It's not an unlawful touching battery. The result is the fear or apprehension. That's the result. So when you look at the tort of assault, meaning the civil assault, you don't have to be touched to fear an assault. And you could have that if somebody goes to like hurl a rock at you and they miss. That's not a battery, nothing touched you, but it's an assault because you were afraid that you were going to get hit with a rock. So with that, you have the imminent fear. So those are your buzzwords for law school exams. Reasonable apprehension of imminent harmful act. So that's your assault. That's why these all get conflated when we talk about assault and battery and when we talk about all of it. So let us see. Battery. The application of force to another resulting in harmful or offensive contact. There we go. Assault, imminent apprehension, reasonable apprehension of reasonable apprehension of imminent harmful or offensive contact. Battery, contact, the application of force to another resulting in harmful or offensive contact. There were battery cases in law school where somebody was like holding a plate and the plate got knocked out of their hand, but it was so entwined with their person that it was a battery because it touched them, because it knocked it out of their hand, blah, 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 blah. So that is the difference between assault and battery. In California, a lot of the felony assaultive crimes are called assault with a deadly weapon, assault causing great bodily injury. Those are all considered assaultive crimes because that's the way the statute in California has worked with assault. Battery in California is simple battery. It is most generally a misdemeanor. There are contexts where it can be a felony. That's not the context here, so we're not getting into it. A simple battery in California is a 242. It's the willful or unlawful use of force or violence upon another person. This is a battery. This is a battery in this context. Oh, it's an assault and battery because you get both. So with that, the slap across the face is a battery. It is in California. It's punishable by a fine not exceeding $2,000 or imprisonment in county jail not exceeding 6 months. It's rare. Like it's really rare that you get people in custody on misdemeanor batteries. So if a misdemeanor battery is reported in the context, not in the context of domestic violence, but in the context of a scuffle at a school or a bar fight or a concert or a workplace or things like that, you will generally see the police take a report. It goes to the DA's office, and if there are no injuries, someone's not really willing to press charges, it can go into a pretrial or pre-thing into a diversion program where that's not even dealt with. Or sometimes somebody will get like a 415 disturbing the peace because they've done a diversion or they've done, anger management classes or something. A lot of these cases get dealt with without anyone having a 242 on their record, especially if they have no criminal history, if it's not in a domestic violence context, etc. Or familial violence. So you really don't see a ton of these getting prosecuted unless the person who got hit is very gung-ho about prosecuting it. And the context I saw that in my personal experience was like neighbor disputes, when neighbors were feuding for months and months and months, and finally somebody put hands on somebody else, because those things get freaking wildly heated. So with that, yes, it is a battery. Yes, it can be considered an assault and battery because it would have put, Chris Rock in reasonable apprehension of imminent harmful offensive contact. You see it in the pictures. He was reasonably, he was anticipating that he was about to get hit because he knew exactly what was coming once Will Smith pulled his hand back. So with that, will this likely go through? No. The LAPD has said that Chris Rock doesn't want to press charges. The DA's office in LA has a lot to deal with. They are not going to go looking to bring a misdemeanor simple battery against Will Smith for a slap against Chris Rock that Chris Rock doesn't want to prosecute. It's just not within their filing guidelines. If the person who got hit doesn't want to do anything with it, they are not going to force it in this context. In the context of relational violence, that's a different decision and a different charging decision. So with that, what's up, Nate the lawyer? New York, no battery, only assault, harm, and assault fear. Well, the states all do this differently, don't they? In California, most of the assaults are felony assaults, assault with deadly weapon, assault with a vehicle, but they don't have to have touching. I've prosecuted an assault with a deadly weapon, a car, where the person was not hit with the car. It wasn't fun to do, but I've done it. So yes, in California, you have both assault and battery, but most assaults result in a battery because most assaults there are also a touching. So it's good to see you, Nate. Thank you. So then a lot of people on social have been asking about Lillian. The DA in LA is facing a possible recall. The DA in LA we're not going to get into the DA in LA, but yes, the DA in LA is facing a second attempted recall after like 40 some odd 40 some odd cities in the DA's jurisdiction have issued a vote of no confidence against the DA, as has the DA's own office. But I'm not going to get into the politics of the LA DA's office. I just sit and listen to my friends about it. So with that, people have asked about fighting words and incitement. And I understand that a lot of people are like, oh, the fighting words doctrine, Why doesn't fighting words apply here? The fighting words doctrine is generally a First Amendment doctrine. It doesn't fall into the criminal context in this way. It's generally allowing the government to limit words of incitement and to limit certain words. Because again, free speech starts with you can say whatever, literally whatever, no matter how awful, how hateful, how disgusting. And then the case law walks back. Well, you can't say whatever. There are little bits that you can't say, and it covers those. So generally, the fighting words doctrine in context is a First Amendment doctrine. That doesn't mean that in the civil context, you don't get a circumstance where somebody sues for an assault or battery in a civil context. And we saw that in the Virginia Giuffre lawsuit against Prince, he who shall not be named. You saw the assault and battery being civilly sued for. In a context like this, could you say, well, I was so inflamed and incited that the only reasonable response was to hit somebody? You could make that argument in a civil case. It's not going to count in a criminal case for the purposes of the DA's making a charging decision. That said, I have seen trials of jury nullification. And if you want the stories, I won't tell you about it. I've seen stories of cases of jury nullification, where when the person who assaulted another took the stand and said, this is why this happened, I've seen jurors go, yep, I understand. I understand. And the jury has found people not guilty based on jury nullification. They're like, I understand that we might meet the elements of the law here, but this isn't the intent of the law. And that's what's going to happen here. This is the criminally prosecuting this is not the intent of the law here. This needs to be dealt with within the venue where it happened. I don't even think it'll be dealt with civilly. I don't think Chris Rock has any damages over this unless there are reputational damages that fall out from this. And maybe there will be, but then how do you prove the reputational damages are not from his joke, but from getting slapped for his joke? I don't know how you parse that for a jury and they're going to be on Chris Rock's side if this ever came in a civil context. I just don't think we're going to see Chris Rock pursuing this legally at all. I have seen reports that Chris Rock did not know about what was about Jada's medical condition, about the alopecia and the hair loss. I was unaware as well. I don't know who else was aware or unaware, but I don't follow the Smiths that closely. So with all of that, legally, yes. Legally, yes. You can have a criminal prosecution here on a misdemeanor simple battery. Yes, you can. Is that practical? No. Is that reasonable? I don't think so. Again, this is up for the academy to deal with, I think. And the academy needs to decide how they're going to deal with it and really decide how they deal with that within what essentially seems like a workplace context, right? The Academy Awards are all a bunch of people in Hollywood that work together. These are actors and comedians, producers, lighting, costuming. I see this as a workplace incident, the Academy being the workplace, and the Academy has to deal with it. That's what I think. So with that, I want to make a point that really stuck out to me in looking at all of this, because this might not apply so much for Will Smith, but it sure applies to you, to your family members, to your kids. This applies to us, normies. Will Smith posted on Instagram, and I'm going to keep the sound off. I will tell you what the sound says, but I'm going to keep the sound off for the purpose of this because, copyright. And I don't want to fight the copyright system. We're going to talk about the DMCA takedown system in just a minute. This post on Will Smith's, they both did look great, but it said, me and Jada Pinkett Smith got all dressed up to choose chaos. This was posted before they went to the Academy Awards. This was posted before anything went down. And the audio of it is to the effect, and I'll just go to Twitter where I actually described it. But the audio also says, I don't know where all the comments went. There were thousands of comments. Did they turn off comments? There were like hundreds of thousands of comments on 484,000 comments. I don't see a single comment. If you guys go on Instagram, let me know if you see a comment. I'm going to go and pull, because I transcribe the audio onto Twitter. Twitter is definitely where I put my quick things. Twitter is hard for me because I do long form and Twitter needs context, and it's hard for tone and context on Twitter. It's very hard for tone and context on Twitter, but let me get to where I shared that. So that's the statement from the Academy. Here we go. Will Smith posted a reel to IG tonight with Jada caption, "Me and Jada Pinkett Smith got all dressed up to choose chaos." The audio of the reel says, "Good morning, everyone. God has let me live another day, and I'm about to make it everyone's problem." Yep. Thank you, Anika. Yep. So if you are not Will Smith, and if you are posting this exact post, and then you get into a bar fight and someone gets injured and you get prosecuted, this social media post is going to be used against you in court. And as a former prosecutor, I'm going to tell you what that looks like. That looks like a prosecutor getting up at an opening argument and saying, this was premeditated and planned. They say they're going to choose chaos. They say, God has let me live another day and I'm going to make it everyone's problem. And in your closing, you are going to say, in your closing, they woke up, they chose chaos, and they were determined to make it everyone's problem. Ladies and gentlemen of the jury, they were determined to make it everyone's problem. And you know whose problem they made it? Insert victim's name here. Their problem. But it shouldn't have been their problem because nothing they did excused this behavior, blah, 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 blah. That is how that closing argument goes. These social posts will absolutely be used against people. Social media posts like this in context of a criminal act will absolutely be used against the person who posted it on social media. So if your 22-year-old thinks that they are being funny, posting something quippy about drinking and driving, God forbid that they do, but post something quippy about drinking and driving, and then they go out and have a few drinks and they don't feel intoxicated and they drive. And then there's an accident further up the road. Are these facts from a case you prosecuted, Emily? Sure are. There's an accident further up the road and traffic stops suddenly, and they're a half a second too late and rear end the car in front of them and kill 3 people in that vehicle. Those posts are going to be used against them, even though it's not their fault that everything slowed down on the road. Or it's 3 o'clock in the morning and they're driving and they've made posts about the fact that they're out drinking with their friends, and someone makes an illegal U-turn in front of the car. But if they hadn't been drinking, maybe they could have stopped in time to not collide with that car and kill someone. Those are going to be used against them. Emily, did you try way too many vehiculars? Yes. Yes, I did way too many vehiculars. So posts like this will be used against them. When I talk to high school students about prosecuting in juvie, I always tell a story about a kid on a baseball team who got prosecuted for an assault because he assaulted someone and caused quite substantial bodily injury with a baseball bat. And all of his posts on Facebook were used against him because he talked about, if somebody wants to step to me tonight, I'm going to fuck them up. And so using that post in the context of someone later in the night getting very seriously injured changes the way you see a person. And that is what prosecutors do. They characterize the person in front of the jury based on all of this context. So the context of the joke is one thing, but the context of the social media posts are also another thing. And it's just, it's something that people don't think of because you don't think that something is actually going to go down later in the night unless you premeditated. In that case, that is where it is. I don't think this was premeditated. I really don't, but it's too close. It's too close in that case, which is why it's hard to be on social media and try to be funny. And then when something goes down, the context changes. The context of this reel before was like, here we are at the Oscars. Will Smith's about to lose. Will Smith's about to win his first Oscar. He's one of few Black men that have won as Best Supporting Oscar. Our Best Actor for an Oscar. That could absolutely be the context. Like, we're bringing chaos to the Oscars. We're about to win this shit. That could absolutely be the context. But after everything, the context gets changed. And that is why it is so important to keep in mind um, what happens, what happens on social media lives forever. And it's hard to be mindful at every moment on social. It really is. But it's a conversation to have with your friends, your family, your loved ones, your kids, more your kids. Because I mean, me, when I'm choosing chaos, I'm staying up past 10 p.m. like that's for real. But this is absolutely something I talk about with my kids, and this is an example where you can talk about it with yours and your young adults and your 20 and 30-year-olds and say, look, this is horse's mouth. This is how prosecutors view this, and this is how police will view it going forward. So this is an example to use, even though this will not go to court, this will not be pursued that way. It's a very good example of how the context of a post can change based on events that later happen and then be used against you. Your words on social will be used against you. JM Orr, I've been waiting on Emily's take on this. Everyone has a take on this. Few have been good or reasonable. I don't know if mine's good or reasonable because I am trying to process through too, being mindful of the fact that there's so much context here, but also being mindful that the context of the joke doesn't excuse the action, but it makes it understandable. So I understand people having empathy, and I understand people being like, I understand why he did it, but that doesn't make it okay. And that doesn't change the fact that it is that is a battery that we saw on TV. And so I think the hardest part for me in all of this, just based on my personal experience as a prosecutor, was watching a lot of the internet say, basically, see, this is what you get. And saying, essentially, your words made me hit you. And that context is hard in the context of prosecuting cases of relational violence because those words are way too familiar to people who've been in that kind of relationship. I'm sure that wasn't what was intended by those who support Will Smith at all and are like, yeah, he should have, versus those who support Will Smith being like, hitting someone's no good, but I understand why he was upset. It's just a hard thing. So understanding is one thing. Empathy for humans is one thing, and we all should have empathy. It's clear that Will was emotional and rattled and angry, but that doesn't give you the right to hit somebody else. It gives it context, but it doesn't make it right. So that's where we're at. I'm sure we will continue to see this. I'm interested to see what the Academy does and says. I mean, the Academy's initial statement was, the Academy does not condone violence in any form. Tonight, we are delighted to celebrate our 94th Annual Academy Award winners. Well, and then you've got, of course, Viva saying the Academy does not condone pedophilia or child abuse, and goes on and talks about Roman Polanski. Viva, did you also post about Harvey Weinstein? He has like 80 some odd things. So I think the Academy probably got ratioed on that, but the Academy needs to figure out how they're going to deal with it and how they're going to deal with it in a respectful way, but also with when you look at violence in context of the motion picture industry, I've been covering the Rust case so much. That is where I'm pondering now. Like, why did we think it was okay on that set to point a weapon at someone? And I'm glad to see that in the in memoriam, Helena Hutchins was honored. But why do we think it's okay to just, even in that context, point a weapon at someone? Like, that context doesn't make it okay. That should never happen. And I'm comparing the circumstance of Hollywood, not the severity of a woman being killed on a film set and someone getting smacked in the face on an award show. But it's just an interesting thing to watch. How is Hollywood and how is the Academy going to deal with this? How are they going to respond? Just like what is going to continue to happen with how Hollywood responds to Alec Baldwin and the Rust shooting. I'm curious. I feel like Hollywood has a set of rules for itself, and I hope that we see conversation about it. We're also going to see conversation about comedy, and when comedy crosses the line, what is the what is the response to that? I mean, we saw Kathy Griffin lose her whole career when comedy crossed the line. And we've seen other people lose TV shows for things that they've tweeted. And so what will the fallout be on this? I don't know. I don't know. But we will see. So that's what I thought. That's what I thought. That's what I think. I think we're going to continue to see. I'm going to continue to watch. I'm getting news alerts that Jada has issued a statement. I should say in summation that Will Smith issued a statement and an apology. It's on, I shared it on Twitter. It's on Instagram. It looks like the comments are turned off on this one, but it's hard to tell on the computer, not mobile. Violence in all of its forms is poisonous and destructive. My behavior at last night's Academy Awards was unacceptable and inexcusable. Jokes at my expense are part of the job. It doesn't mean they're okay. Like, it doesn't mean punching down at someone who's dealing with an autoimmune disease is okay. It doesn't make it okay. But a joke about Jada's medical condition was too much for me to bear, and I reacted emotionally. Okay. I would like to publicly apologize to you, Chris. I was out of line and I was wrong. I'm embarrassed. I don't doubt that that's accurate, that he's embarrassed. I'm embarrassed and my actions were not indicative of the man I want to be. There is no place for violence in a world of love and kindness. I would also like to apologize to the Academy, the producers of the show, all the attendees, and everyone watching around the world. I would like to apologize to the Williams family and my King Richard family. I deeply regret that my behavior has stained what has been an otherwise gorgeous journey. For all of us, I am a work in progress. And I think all people are a work in progress. He acknowledged it. So we'll see. We will see. We will see. And you guys get to decide how you take it. He's not really apologizing to us. He's apologizing he is, to everyone watching around the world as us. And people get to decide what they think. And that's people will decide what they think. The acceptance speech was hard for me because he was defending his actions. But it was in the moment. It seemed to be completely off the cuff. And he was saying, I wanted to defend my family. And I think that that's the truth, that he wanted to defend his family. It doesn't make it okay. This was not the way to handle it. So that was an apologizing to Chris. I don't know if Chris has accepted the apology or not, but I will continue to update that thread on Twitter that updated some of people's takes on it and updated and the things that were going on through the night. But, Kanye was banned from the Oscars for words that were said. So are we going to see this treated the same, or are we going to see this treated differently? Will Smith said, I shouldn't have done this. This is not okay. This is why I did it. I'm sorry and I'm embarrassed. And I don't doubt that any of that's true. I really don't. I really don't. At least he said he apologized. Okay. So that's there. Jada said, I was seeing news alerts about that too. Jada recently, as we were live, said that this is a time of growth. So with all of that, it's really, we've got, oh my God, we're an hour and 27 minutes in and we definitely have more than a half an hour of stuff to talk about. So I am going to move on. I could have been more brief with that, but sometimes you still process out loud. So hopefully, did I not say Grammys? Did I say the wrong thing? Kanye was banned from the Grammys. If I misspoke, I misspoke because I meant Grammys in my brain. I absolutely did. My question is, where is Chris Rock's apology? I don't know if Chris Rock has apologized or not. We will see. I mean, Chris Rock should explain if the joke was pre-written, if he knew, if he didn't know. There should absolutely be something from him, but we will see. We will see. All right. With that, it's time to talk about DMCA, Bungie, video games, and YouTube. We're going to talk about YouTube. We're going to have a very meta moment talking about YouTube. I am sure, by the way, that Hogue Law will absolutely be breaking this down. He covers the legal side of a lot of tech and gaming and is much more dialed into that community than I am. I am very dialed into DMCAs because copyright, but he is much more dialed into the gaming side of it. I am sure there is more that I don't know about Bungie. I know what Destiny and Halo are. That's where I'm coming from. So let us go. Jake Thompson said, why would Chris Rock apologize for doing his job? I think that whenever you cause someone hurt and see genuine hurt as a human, you want to say, I didn't mean to cause hurt. I don't think Chris Rock meant to hurt Jada. You could see that she was hurt and you could see that that Will Smith was hurt. And I think as a human saying that there is hurt is, and acknowledging that you've hurt someone is necessary to say, I did not intend to cause hurt, and I see that I caused hurt, and I am sorry for causing that hurt. So with that, I think you should. You guys are saying it's on Twitter, so I'm going to look real quick, and then we're going to talk about Bungie. Let's see. Because if it's on Twitter, it will be readily apparent. Why is Ethan trending on Twitter? I don't know. I don't know. Let's see. Chris Rock. Will Smith apologizes to Chris Rock. Chris Rock apology. Let's see if there is one. Latest. Let's see. I don't see anything saying Chris Rock apologized. If he did, I will find it and link it down below later, and I will link it in updating that Twitter thread. I'm only seeing stories about Will Smith apologizing to Chris Rock. And again, it's really up for Chris Rock to accept that apology, but he did apologize to the rest of the world, and everyone is going to continue to have conversation about this. So we will see. We will see. We will see. Again, I will link Natalie Lawyer Chick's video. I think Nate the Lawyer did a video, and I will go take a look at that. I have not seen it yet. But at the end of the day, yes, Katya, it's definitely not Jada's fault. Jada's feelings were hurt. Her feelings are allowed to be hurt. She's going through something that's painful. So it's not her fault at all. She's not responsible for how her husband reacted. Let us move on. Let us move on. Thank you, mods. And thank you, Law Nerds, for being Law Nerds. I forgot to give a disclaimer because sometimes I forget. Pop a 1 in the chat if you're new. We do have chat rules. I know the mods enforce them. We don't diagnose people with mental illnesses. We don't name call people. We don't shout people down. We absolutely listen to one another and try to have compassionate conversation, even when we disagree. And sometimes people are going to have different takes on what happened with Chris Rock and Will Smith. And I think with that, it's important to listen to one another and see how people have different perspectives, because everyone's take on this is coming from their own perspective. And hearing what people's perspectives are, which is why I made clear my take on this is that I'm a former prosecutor and I'm an attorney, and I'm looking at it through that lens. And what I can say is, through that lens, this is how I see it. But I also acknowledge that there are all these other people who have different lenses and more context and different responses to this based on those lenses, those contexts, their history, the life that they've lived. So with that, when we listen to each other, we all might learn something, because there's a lot more context here. So Ethan is trending because of a pod he did last night, full train wreck. Okay, well, I haven't even jumped into that, and I'll definitely do that later. So we need to talk about video games and DCMA trolls. I meant to swoop and then I didn't swoop. So now I'm going to swoop again. Where are we at? 132. All right. Let us swoop. Let us go talk about DCMA takedowns. For those of you that are new here, thank you. I saw a bunch of ones in the chat. Don't forget to like and subscribe. I appreciate you. We do have chat rules. Why? Because my chat is not Thunderdome. Why? Because I don't find that to be a pleasant experience on the internet. So our chat is very much not like other chats that you may see on the interwebs. And that is because I ask for it to be that way. So with that, I got tagged in this on Twitter, and y'all, I tell you all the time, thank you. Thank you. Thank you. When you tag me in stories that you think are interesting, think I will find interesting, have more context, have different context, I am fascinated. Haunted Shadows Legacy. Yeah, I will interchange DMCA and DCMA all of the time. I try to help it, but sometimes the acronyms, the letters fly out of my name in reverse order. I share very openly that I am both dyslexic and ADHD, and in my brain, things flip around on me. And though I try to get it right, sometimes I will get it wrong. And we all know when I say DCMA, I mean DMCA, and I will try to do my best. I actually try to look at it as I say it, because I do flip them around. So, Late Night said the former LA district attorney is calling for charges to be filed against Will Smith. Cooperation is not necessary as state. Yeah, the state can charge, but that's dumb. Which former district attorney? I'd be shocked if Jackie Lacey is calling for that. So I need to know which former LA district attorney. And are they running for, is it Cooley? Late night, tag me in something. I want to see more about that. I think that's kind of dumb. Yes, the LA DA's office can bring it on their own, but I don't like it. Okay. I swooped. It's time to talk about Bungie. And I'm sure a lot of you are finding my channel because of this. Go ahead and do the likey, subscribey, YouTubey things. I break down law, and we're going to talk about this. Again, law nerds, thank you for tagging me in stories you find interesting. It's fantastic. It's how I know what you're interested in. And it's absolutely one of the things I consider when I go to look at stories. So we're going to look at PC Gamer first, and then we're going to go to the text of this lawsuit and give it a first look. So I think I swooped. We're all going to learn something today. Bungie slams YouTube for DMCA security loophole and lousy customer service. The studio has filed a lawsuit against scammers who fraudulently forced the removal of multiple Destiny 2 videos. Bungie has launched a lawsuit against the perpetrators of last week's quote-unquote fraudulent Destiny 2 video takedowns, saying that the removal of community-created videos caused the studio, quote, significant reputational and economic damage. I don't doubt that. At all. I don't doubt it at all. Because a lot of how games grow is by those types of videos. That's how games grow. I'm trying to make this bigger. Let's see. Wrong screen. I made the wrong screen bigger. All right. Me screwing things up on my own, obviously. Let's see. The suit is also highly critical of YouTube's easily gamed reporting system, which we will talk about in a minute. Which it cites as the primary reason that the attack on Destiny 2 content creators was successful in the first place. Destiny 2 being a video game, Bungie being the underlying creator of the video game, even though I believe Bungie is owned, their parent company is Microsoft, but Bungie is the game developer. Hopefully that gives some context to those of you who are like, I don't know what Bungie is. A big video game developer, Destiny 2 and the Halo games. It was unclear why the takedowns were being issued because they seemed to impact videos that Bungie policies specifically allow, and making the whole thing even weirder, some of Bungie's own content was also targeted. Bungie said last week that the takedowns were fraudulent and that it was working with YouTube parent company Google to reverse all of the copyright strikes that resulted. It also found that many of the requests were issued by a quote-unquote bad actor, unaffiliated in any way, who may have taken the action to retaliate for a recent round of legitimate Destiny 2 video takedowns. Here's the thing within the video game community on Twitch and on YouTube. There are a lot of game streamers, and a lot of games have ways that they allow their games to be streamed. You guys are saying Bungie is no longer owned by Microsoft, and they are owned by Sony now. Perfect. Owned by Sony, parent company. So with that, there are game developers that allow their games to be streamed. A lot of times when games are streamed, it technically isn't transformative because playing the game is not transformative use. But studios have their own ways that they allow games to be streamed, because I think the studios realize and recognize that part of the way that their games grow is by people watching their favorite YouTubers play these games, and that this is a brand of their advertising. The amount of games that my child has wanted to buy because he's watched a YouTuber play them, but also the amount of things I've wanted to buy because I've watched a YouTuber talk about it. It is a type of marketing that can be very, very effective. And so game developers allowing their games to be played on stream is beneficial for them. It's not good if a game developer allows it and then all of a sudden big YouTubers who stream their game are being taken down, because immediately the YouTuber is going to look at the company and be like, yo, WTF, I thought we were cool. Why am I getting copyright strikes? And copyright strikes can be issued back to back to back and can take down your channel, if not for a week, longer, or permanently. So in YouTube, this is a very, very big problem that you can lose your channel over these types of copyright strikes. And you can lose your income even if you're blocked for like a week or two or more. So it goes on to say that the lawsuit says in mid-March, well, we're going to get to the lawsuit. The defendants also allegedly sent abusive messages to the Bungie's legitimate IP protection partner. Quote, the Destiny community was bewildered and upset, believing that Bungie had reneged on the promises to allow players to build their own streaming communities on YouTube channels on Destiny 2 content, the lawsuit states. Destiny community members were also misled to believe that Bungie's brand protection agent was also fraudulent, causing confusion among users as to the authenticity of legitimate DMCA notices. Bungie has had to devote significant internal resources to addressing it and helping its players restore their videos and channels, an effort complicated by the fact that while YouTube has a form that allows anyone to claim to represent a copyright holder and issue copyright strikes, it has no dedicated mechanism for copyright holders who are being impersonated to let YouTube know about the DMCA fraud. That's a fact. Bungie's criticism of YouTube in the lawsuit is surprisingly harsh. I'm not surprised. The lawsuit describes YouTube's DMCA policies as flawed, and we're going to get there because we're going to just go through the suit. Bungie issued statements on Twitter saying that they were aware of the copyright takedowns and they were actively investigating it, and then this lawsuit filed. With that, we should go to the lawsuit. But before we do, there is one lawsuit I want to talk about first. Let me see real quick. I thought I had this pulled up and then I don't, because we're professionals here. This lawsuit was just recently dismissed on a motion to dismiss, and I'm going to pull that to do deeper content on this. But there is a lawsuit against YouTube, Business Casual Holdings LLC against YouTube, Google, and Alphabet, stating that Business Casual Holdings seeks monetary and injunctive relief against defendants for failure to maintain and reasonably implement a repeat infringer policy as required by the DMCA. To qualify for protection under the safe harbor provision of DMCA that insulates service providers hosting third-party content, a service provider must meet a set of threshold criteria, including a requirement that the service provider seeking shelter in the DMCA safe harbor provision must have, quote, adopted and reasonably implemented a policy that provides for the termination in appropriate circumstances of subscribers and account holders of the service provider system or network who are repeat infringers. So this is a lawsuit saying that YouTube is not dealing with its repeat infringer policy when it comes to people who are using protected content. YouTube's repeat infringer policy states, if your channel is a part of the YouTube Partner Program, you're eligible for a 7-day courtesy period. After 3 copyright strikes, you'll have 7 additional days to act before your channel is disabled. Yeeted. During this period, your copyright strikes won't expire and you can't upload videos. Your channel will remain live and you can access it to seek a resolution for your strikes. If you submit a counter notification, your channel won't be disabled while the counter notification is unresolved. So this is going through, again, issues with YouTube's policy for repeat infringers. But the policy doesn't also cover people who repeatedly make false claims. So YouTube has been sued for this. I'm sure there are other lawsuits for this about them not enforcing their own policies, which is y'all. I'm not a conspiracy theorist. I'm not. I'm really not. But when I get yeeted in the middle of my stream, yeah, Jake Thompson, F in the chat. Put an F in the chat. Everybody put an F in the chat. When I get yeeted from my own stream talking about Google, I have questions. I have questions. Oh, F, F, F. I have, I have questions. Thank you, chat, for putting F's in the chat. Look, this is going to be a hard one to talk about, clearly. But we're going to keep talking about it because look, I like YouTube. I think YouTube generally does a pretty good job of trying to deal with this stuff. But there are valid criticisms of the way YouTube deals with people who use both the DMCA takedown and the copyright takedown system as a way to not just troll with each other or troll others, but as a way to retaliate. It is not meant as a retaliatory system. You know, when you've got a creator on the platform saying, you know, fuck that person, go issue strikes on their, you know, go claim their videos and stuff. That's a problem. And YouTube doesn't always enforce that well. But we're going to talk about this lawsuit and the changes that YouTube can make because it's fair to say there's room for changes. When a large company, like a large company, can't rectify the fact that they are being trolled over their own content and don't have someone to contact at YouTube, that is a problem. Because imagine if it's, you know, I don't know, me or any of the other law tubers who deal with this. Some have direct contacts at YouTube, some don't. What can you do? And how do you fix it as a creator? And generally the answer is, well, go and complain about it on Twitter. How is that the answer? So let's go through this lawsuit. Of course, we need to redo share permissions because, you know, we're professionals here and we got freaking yeeted. Yeeted. My first problem here is that this is a suit against John Doe's. You are allowed to bring suits against John Doe's, but you have a very short period of time to find who they are. Generally, you can bring suits with John Doe victims and one named defendant and other John Does. We saw this when we talked about the Mike lawsuit ages ago. They named like one defendant that they could serve and the rest of them they couldn't. It was one of the things that the amazing and sassy Judge Anderson complained about, was that when you improperly join all these defendants, it's fine, but did you even do your due diligence to find who they are? In this case, I don't think they can find who's doing this without being able to issue subpoenas, which means you need a lawsuit, but then the clock is ticking. So they are going to have to get these subpoenas quickly done so that they can actually name proper plaintiffs in this case. And with that, there's already been me getting ahead of myself, but also me getting ahead of myself. There's already been a notice from the court because everything closed on me. We've got to open it all back up again, because live streaming is, you know, live. When you guys are like, why do we sometimes do uploaded videos? Well, with the unpredictability of live streaming, sometimes you need to. All right, this was issued by the court yesterday. So the lawsuit was filed, and then there was something today too that I'll go over. The lawsuit was filed on March 25th. Today is March 29th. This was issued by the court yesterday, March 28th. The court has received your case documents and has identified the following items to be addressed. Please note, any underlined points of reference below will contain a link to source materials. Summons form incomplete. You have to sue someone. Summons form incomplete. Summonses as filed do not include complete and or correct party information as required by Federal Rule of Civil Procedures 4A1. Please file the corrected summonses with complete party information by going to other documents, and then it tells them how to do it. The problem is they can't summon them because they don't know who they are yet. And they don't know who they are yet because they need information from Google to figure out who they are. But they need the subpoenas and the power of the court to subpoena them. You can't just ask Google, hey, Google, can you give me this information? Google wants to protect its user information. They're like, make the court make you do it. And if the court doesn't make them do it, then we're in a like chicken egg issue, because they need the subpoenas because of the lawsuit to find the information of who to sue, but you need someone to sue. So the fact that they don't even have one defendant could be a problem for them, but they are issuing this lawsuit for fraudulent DMCA notices, false designation of origin, copyright infringement, business defamation, violation of the Washington Consumer Protection Act, and breach of contract. With that, though, they've also... Could you say... Siri, I didn't say your name. They've also issued the initial subpoenas to Google to try to find this information as of yesterday. So this has been populated as well. They are trying to get to this information as quickly as they can, and they need to do it quickly because they have about 90 days to serve these or the case will be dismissed due to failure to prosecute. So let us look at what they're suing for. Welcome, everyone. We're going to talk about video games and DMCA takedowns and law things. Law things. This action arises out of a series of fraudulent DMCA takedowns, Digital Millennium Copyright Act, that were unauthorized and malicious, that an unauthorized and malicious actor or actors provided to YouTube with respect to content that supposedly infringed Bungie's copyrights on its popular and successful Destiny franchise, disrupting Bungie's community of players, streamers, and fans, and causing Bungie nearly incalculable damage. As discussed herein, defendants were able to do this because of a hole in YouTube's DMCA process security, which allows any person to claim to be representing any rights holder in the world for purposes of issuing a DMCA takedown. In other words, as far as YouTube is concerned, any person anywhere in the world can issue takedown notices on behalf of any rights holder anywhere. A disgruntled infringer or a competitive content producer, for example, can issue takedown notices purportedly on behalf of Disney or Fox or Universal or even Google itself. All they need to do is 1, fill out the video removal form located at, we're not clicking the link, 2, have a Google account, including upon information and if one created the same day with fake information, 3, fill out the information and click verification buttons, fraudulently certifying that they have the right to submit the takedown request with no verification done by YouTube. So the no verification done by YouTube means that they just have to affirm it. But again, most people I think that do this, and there are people who do this as a punitive or a I don't know, dick move, just have to affirm it on the belief that YouTube's never going to come after them. So it's like, okay, well, they're not going to find me. They're not going to find me. So I can just affirm under penalty of perjury who's going to come for me and do it. And that's one of the things I was nervous about when talking about this case is I don't want to give people ideas about how easy this is, but I think it's already widely known by people who do shit like this anyway. So that's where we're at. It's more important to talk about than not to talk about. Between March 17th and March 22nd, a malicious actor or actors exploited that security loophole to issue takedowns purportedly on behalf of Bungie to YouTubers and streamers who had, with Bungie's permission as granted by Bungie's legal policy on media located at, uploaded videos of their gameplay to YouTube. I'm glad that they have a policy. All video game creators should. Between March 17th and March 22nd, a malicious actor or actors exploited that gaping security loophole to issue takedowns purportedly on behalf of Bungie to YouTubers and streamers who had, with Bungie's permission, granted in Bungie's legal policy. Using a fake Gmail address that was, upon information and belief, newly created, which did not match the address used by Bungie's brand protection vendor for legitimate DMCA takedown notices, although it has a similar syntax to those addresses, upon information and belief, having been deliberately chosen so as to cause maximum confusion among recipients and lead them to believe it was legitimate. Oh, I'm curious. Hold on. I should probably keep reading, but I'm going to go to the subpoenas. There was a screenshot in this subpoena. I'm wondering if they add the name of the address that that issued the takedowns, because there's a screenshot of a takedown in here. Let's see. This is the subpoena asking for all the documents and who it gets sent to. This is the declaration. Here's the screenshot. Let's see if we can. This is a little bit blurry on my end too, guys. So I'm going to do my best to look at the copyright strike. And let's see if it includes who the strike came from. It doesn't say. Strike issued. Content removed by Bungie Inc. Interesting that that's what it's saying. who removed it. The included subpoena is sought to obtain the identity of one or more alleged infringers in connection with this matter, specifically those who issued fraudulent takedown requests as described in the complaint. Such information will only be used for the purpose of protecting rights under Title 17. The following is a true and accurate screenshot capture indicating one of the false DMCA takedown requests. It's interesting that this shows that the request is coming from Bungie, because they're allowed to say who it's coming from in the language of the request. So let us get back to the actual complaint. Notices that were otherwise inconsistent with the substance of Bungie's legitimate DMCA notices. Doe defendants have issued a wave of takedown notices targeting non-infringing Destiny 2 videos. Using the same fake Gmail address that was used to issue a wave of fraudulent takedown notices, Doe defendants circulated messaging to affect uploaders that appear calculated to discredit the authenticity of the takedown notices legitimately issued by Bungie's authorized brand protection vendor by claiming falsely that DMCA notices attached to the authorized vendor's email address, David Thomas CSC@gmail, were also fraudulent. Using a second fake Gmail address that was, upon information and belief, newly created, which did not match the addresses used by Bungie's brand protection vendor, Doe defendants sent abusive messages to the email address of Bungie's authorized brand protection vendor. They're on a vendetta streak, perhaps. This caused Bungie significant reputational and economic damage for obvious reasons. As discussed below, the Destiny community was bewildered and upset. I don't doubt that at all. I don't doubt that at all. Believing that Bungie had reneged on promises to allow players to build their own streaming communities and YouTube channels on Destiny 2 content, Destiny community members were also misled to believe that Bungie's brand protection agent was also fraudulent, causing confusion among users as to the authenticity, and legitimate DMCA notices. Bungie has had to devote significant internal resources to addressing it and helping its players restore their videos and channels, an effort complicated by the fact that while YouTube has a form that allows anyone to claim to represent a copyright holder and issue copyright strikes, it has no dedicated mechanism for copyright holders who are being impersonated to let YouTube know about the DMCA fraud, as detailed below. This meant that Bungie had to work through several layers of YouTube contacts before it could adequately communicate and begin addressing the problem. I wonder if YouTube will actually address this at some point. It feels like they should. It feels like they should. Though Bungie does not currently know the identities of Doe defendants whose anonymous conduct just occurred days ago, it will discover them soon via 512H subpoena or otherwise, and will promptly amend this complaint once it does. I mean, they roughly have like 90 days. For now, though, and particularly given the ease with which malicious actors can exploit YouTube's flawed DMCA practices and harm Bungie's community, Bungie brings this action to recover from Doe defendants' tortious and illegal conduct, and frankly, to demonstrate to anyone else stupid enough to volunteer as a defendant by targeting Bungie's community for similar attack, that they will be met by legal process. Literally the legal fuck around and find out is what they just said. That's literally what they just said. They said, fuck around and find out. We are not playing, because Bungie has the resources to do this. Jurisdiction and venue. They're in California. Until we know where the Doe defendants are, I'm not going to address jurisdiction and venue. Background: the Destiny community. Destiny 2 is a shared world online first-person shooter available across multiple platforms, including PlayStation 4 and 5, PC, Strata. I don't know what that is at all. Xbox One and Series X consoles. Destiny 2 boasts a community of tens of millions of players worldwide. I don't doubt it. But members of the Destiny 2 community do more than just play the game. Content creators build fan followings of their own for their gameplay or commentary, which is often streamed to followers and subscribers and or uploaded to YouTube for asynchronous viewing. Thank you. Scorpion said Strata is Google's video game streaming platform. I had no idea what it is. For instance, YouTubers like My Name is Biff. That's a fantastic handle. Spelt Biff. YouTubers like My Name is Biff and Dado have roughly 1 million or more subscribers who watch their videos about Destiny 2, its lore and gameplay. And this isn't just gratifying for Bungie, though seeing the community's love for its game is certainly that. Destiny's base game is free to play, as is character leveling. Gamers can play Destiny 2 without purchasing anything at all unless they want to. Instead, Bungie's income stream comes from the Destiny 2 game. Income stream from the Destiny 2 game is entirely based on additional content gamers choose to buy. Downloadable content, including expansions, additional campaigns and storyline, in-game currency, silver, I guess that's the in-game currency, which players can purchase for real money and use in Destiny 2 world to purchase cosmetic items for their characters. The amount of money I sometimes spend on cosmetic items for my character. The amount of money I sometimes spend on cosmetic items for characters. I love customizing a character. Free to play always screws me because I will always pay. I will always pay. You should see my Pokemon Go avatar. She's glorious. Seasonal content and other in-game features and additions. Back in the day, y'all, side note, my farm in Farmville had some of the coolest trees ever. I'm just saying. They will, free to play will always get me. It will always get me. So this paragraph goes to the heart of why these takedowns are so difficult for Bungie, because I imagine one of the ways that people choose to buy is because they want their character to look like their favorite streamer. Their favorite streamers buy this, and then others want to buy it because that's what their streamer has done. The streamers will show you what the seasonal content looks like and in-game features, which is a huge way to sell this. So I imagine that this is a big hit if the creator community feels that the game developer is not supporting them. Thus, unlike a more typical model in which companies earn by retailing individual copies or downloads of the game, Bungie generates revenue from Destiny 2 if and only if its players find the game experience so compelling and enjoyable that they want to buy additional content. As a result, the level of connection and community that Bungie's players share directly affects the bottom line. Emily, keep reading. Just keep reading. Bungie's intellectual property policy and enforcement. Bungie is the owner of more than 200 registered copyrights and trademarks. Bungie's registered copyrights cover, among other things, its game software, its game as audiovisual works, various elements of the game, including music and art used in games. Because those elements are integral to the gaming experience, and because Bungie wants its community to be able to share and discuss Destiny gameplay and elements, but also wishes to protect its intellectual property, Bungie has adopted a comprehensive policy governing its gamers' use, display, and performance of Bungie's copyrighted works. As noted in its intellectual property policy, Bungie strongly supports the efforts of our community to produce non-commercial content using video, images, footage, music, sounds, dialogue, or other aspects from its games, subject to a few conditions, generally approved streaming and commentary through approved platforms like Twitch, YouTube, or Facebook. What's interesting to me is how they describe non-commercial. Because if you monetize a video, is it a commercial use or is it not a commercial use? That's where these things start to get into the, like, we've got to parse what you mean. Non-commercial can mean like you can't put it on a shirt and sell it, but you can monetize a stream of it. So I'm interested by what they mean by non-commercial, but that is tangential to what we're talking about here. And I will not go down that mental rabbit hole at the moment. We will refrain and do that a different time. Bungie reserves the right to enforce its intellectual property rights against infringers who violate the guidelines in its intellectual property policy, community standards, and code of conduct. Bungie permits players to create videos using Destiny gameplay. Bungie permits players to upload gameplay videos to third-party video sharing services like YouTube. Bungie specifically notes that the sharing of videos that are primarily Bungie-created content, trailers, or cutscenes is not allowed. So the gameplay, yes, just using the intellectual property and not doing commentary or gameplay, no. And this is where we get into how Bungie defines like fair use or transformative use. Bungie uses a vendor, CSC Global, to handle its digital Millennium Copyright Act, DMCA takedown notices for infringing content that does not comply with their intellectual property policy, including content uploaded to YouTube. YouTube's DMCA reporting form requires that the reporting party use a Google account if the reporting party processes DMCA requests via a YouTube content management product creator studio, or content manager. For that reason, CSC created and uses this particular Gmail for its DMCA work. At no point does CSC issue takedown notices on YouTube uploads related to Destiny without specific approval from Bungie's legal department. Well, it's nice to know their process for doing this. It's a very thorough process. On or about March 2nd, 2022, at Bungie's direction, CSC initiated a series of DMCA takedowns, 41 in total, relating to infringing content that had been uploaded on YouTube. The early March takedowns, all 41 early March takedowns related to music from Destiny 2's original soundtracks. Upon information and belief, YouTube's actions in response to the early March takedowns were complete on or about March 16th. Doe defendants' retaliatory attack on the Destiny community. Well, this is interesting. I'm very interested. So they are positing, again, lawsuits are allegations and shade. They are positing that this was a retaliation for the early March takedowns that they say were centered around music in game. Music in game is a huge separate issue from gameplay. I'm sure we will end up talking about it over on vidIQ next month. I'm sure this will come up because we talk a lot about gaming uses. All right. Doe defendants' retaliatory attack on the Destiny community. Upon information and belief, Doe defendants were among the YouTubers whose videos received legitimate DMCA takedowns as part of the early March takedowns. Upon information and belief, the email address connected with the takedown notices that impacted Doe defendants' account was David. Am I going to have to try to figure out the difference between these two things? Oh my God. This hurts my brain. So David Thompson CSC versus this one, David. Oh, this is the David Thompson CNC. So they're saying that those are the legitimate ones. Beginning on March 17th, Doe defendants began submitting unauthorized DMCA takedown notices to YouTube for videos that allegedly infringed Bungie's copyrights. Upon information and belief, created a fake name at CSC at Gmail, Google accounts in order to submit fraudulent takedown notices. Interesting. So there were whatever names CSC. I would imagine you would see like similar names to that so that it's confusing, because trying to parse if it's THOMS and not Thomas or something, it would be hard to parse. Upon information and belief, Doe defendants identified themselves as Bungie Inc. when submitting some or all of the fraudulent takedown notices. Alternatively, upon information and belief, Doe defendants identified themselves as Bungie's authorized agents. That's where some of these causes of actions come from. Doe defendants had no authority to submit any of them. Despite that, Doe defendants submitted fraudulent takedown notices targeting many members of the Destiny community, including My Name is Biff. I love this name so much, and I'm going to have to go check out this content just because I think it's amazing. Aztec Ross, The Phoenix, Promethean, Archival Mind. I like that they have a variety of streamers represented here, not all just with large followings, because these are large followings down to, a channel with under 20,000. Good representation, Bungie. Indeed, Bungie's own official Destiny YouTube channel got hit with a fraudulent takedown notice. I mean, I can see somebody being mad. They're like, we're going for all of you. I can see it. Thanks to YouTube's easily gamed reporting system, the attack was a success and the videos were removed. And YouTubers giving copyright strikes that under YouTube rules threaten the future viability of their YouTube channel. Yeah, it's such a dick move. Upon information and belief, Doe defendants disseminated misinformation via an email from the fraudulent address Jeremy Wild and CSC at Gmail. In this email, Doe defendants claimed falsely that the legitimate agent's address had been issuing false takedowns for years, causing confusion among recipients. Well, those emails can be traced. It's going to take a little time, but emails can be traced. Scorpion142. I'm not familiar with any of these streamers, and I mispronounce shit all the time. No offense is meant. It's just my brain. It's just my brain. I pronounce names I do know all the time. Upon information and belief, Doe defendants filed a fraudulent DMCA notice targeting their own YouTube channel, purportedly on behalf of Bungie, using the fraudulent alias Jeremy Wild and CSC. Upon information and belief, Doe defendants filed a fraudulent copyright counter notice with YouTube, claiming both the legitimate and the fraudulent copyright notifications were fraudulent. Oh, Jesus Christ. This is a mess. This is just a mess. This is all a mess. But once the forensics are done, it will be less messy. It'll be very interesting. So Bungie is claiming that they did a bunch of takedown notices at the beginning of March and that these takedowns were retaliatory fake takedowns. It will be very interesting when they go through the process of subpoenas and find out who these streamers are, how much they name everybody. I'm fat, like I want the tea. Who did it? I'm in for the whodunit of it all. I want the tea. I want to know. I want to know. I am now curious. I feel like this is going to be beauty community level drama within the Destiny gaming community, and I am here for that tea. Me, will I be going down a Destiny community rabbit hole? Yes. Do I want all of the drama? Yes. I want, because there's going to be tea. Once we find out who it is, there is going to be tea. This is beauty community level drama inside the Destiny community. The community impact of the attacks and Bungie's response. Doe defendants' attack sent shockwaves through the Destiny community. Oh, I'm going to be going to Reddit after this. I want to know. I want to know. Community members described the loss of the falsely struck content as heartbreaking, horrible, and legitimately a tragedy. Footnotes 1, 2, and 3. Footnote 1, web archive. Footnote 2, a YouTube video. Footnote 3, a web archive Twitter Twitter post. Content creators described the chilling effect the false takedowns had on their work, saying, "I'm scared to make new Destiny videos, let alone keep the ones I've already made up." Well, yeah, because if you get 3 strikes, your channel's yeeted, and most content creators don't have a way to fix it. I empathize so much with that. Let's see. This goes to Reddit, Destiny Reddit. Of course, Reddit is involved. I'm just worried that my channel is gone forever because of this. A very fair concern, and that's from Twitter. As one community member explained, some of the people running these channels used their main accounts for this, couldn't take the risk. Just unlisting videos doesn't protect them from strikes at all. That's actually true. It was self-delete or get permanently blacklisted by Google. Even then, you can get removed on strikes from videos that you have since deleted. It can happen. It can happen for things that are privated. It can happen. The community's sorrow quickly turned to anger. Many fans reacted with disbelief and frustration, saying, "Bungie has always been a community that isn't a shitty soulless corp." I mean, we don't talk about Niantic. It seems like the relationship between content creators and Bungie is really good. Bungie has always been a company that isn't a shitty soulless corp with this stuff, and I'd super appreciate it if y'all can send this up the flagpole to whoever can look at this. Footnote 7, which is a link to Reddit. And this is the type of thing that alienates a dev company from their fans. It's damaging to the community, and I don't understand it, TBH. Yeah. Yes. Accurate statement. And that is also from Reddit. This is the proper use of Reddit. This is a proper use of Reddit in a lawsuit, not Trillery. It's showing how the community's been damaged. The Trillery use of Reddit posts shows that, they said shit on Reddit, and I'm suing over shit that's said on Reddit. You can't sue the mods of a Reddit for shit that's said on Reddit. But showing the damage to the company is a proper use. Hey, this has hurt the company. It's why we're suing, because we have damage here. So proper use of Reddit. I get it. Community members felt disregarded and betrayed, saying it feels like they don't care or are complicit. Because the false takedown emails use the same CSC identification style as the authorized agent, many members believe these were authorized takedowns, saying Bungie hired a third party to enforce copyright. This is 100% on Bungie. Again, showing damage. And their reaction was not confined to the Destiny community. The fraudulent takedown notices and their aftermath also garnered significant media attention, being reported on at gamesindustry.biz, gamespot.com, PC Gamer, Forbes, and even German web portal WinFuture. Okay. On March 18th, 2022, when the first complaints about the takedown notices began coming to Bungie's attention, Bungie's Deputy General Counsel, James Barker, reached out to Bungie's brand protection team at CSC to inquire. I imagine that call went something like, excuse me, what the fuck? Take probably not in such strong languages. Takedown notices normally come through legal. Legal didn't approve these. What is happening? What is happening? I imagine is how that conversation went. So Deputy General Counsel, lawyers for Bungie, reached out to their brand protection team to inquire about the takedown targeting Aztec Cross that was described via social media, noting that he did not see the Aztec Cross takedown in the CSC provided list of completed or any request targeting Aztec Cross, and asking CSC to confirm whether there was a takedown. By email roughly a half an hour later, CSC responded that it had no such record either, nor any second records that would suggest any such takedown had occurred by mistake, and asked for more information so that it could confirm with certainty that it was not the source. I mean, for a company dealing with this, it seems that they have done a good job dealing with this. They, it came to their attention. They reached out to their company and they said, can you please explain what's happening here? Responding directly to their community. I'm not mad. I'm not mad about that at all. I'm actually rather encouraged that they immediately reached out and took action. What they kind of have to protect their company reputation at this point. After being provided details on the timing of the copyright complaint filing against Aztec Cross, did I pronounce this Aztec Ross earlier? I might have. Aztec Cross, I can now see the Aztec. I can now see the differentiation. It's hard. Names are hard. CSC confirmed that they had no record and the complaint likely did not come from them. Mr. Barker then forwarded the image of the takedown from the user, noting the oddity of the fact that the notice indicated that the content was removed by Bungie Inc. when any removals handled by CSC would not have used that language, and Bungie has not authorized anyone else to issue takedowns. I will say, there's the photo in here too. I should have just kept reading. I will say, as a content creator, I have seen not copyright strike notices, but copyright claim notices that come from major companies, that come from the companies they hire. From my personal experience as a creator, when it comes from a company that's hired, that's normally the company name used so that they don't show that it's coming directly from the corporation, because it's actually coming from the company hired to do the takedowns. Any of you that watch the drama commentary community, there was a period of time where Trisha Paytas had videos being taken down. They weren't saying they were coming from Trisha Paytas. They're coming from this third-party company that's doing the copyright claiming, and that's generally the procedure. I'm not surprised that they didn't name that in this lawsuit, because they don't want the people who are doing this to troll them better and to create more headache. But I'm not surprised that they're saying it doesn't come from Bungie Inc. So this is the screenshot that's included in the subpoena request as well. Based on those issues, Mr. Barker asked if CSC believed it could be a spoof, and CSC responded that it believed so, but would need until Monday, March 21st to confirm fully. In response, Barker directed CSC to do what it could to get the video reinstated, as it did not violate Bungie's guidelines. The thing is, if they don't issue the strike, they don't have access to it on the back end to do anything about it. Keep reading. I'm sure that will come up. In response, Mr. Barker directed CSC to do what it could to get the video reinstated. CSC issued a retraction notice requesting reinstatement of the video, but on Monday, March 21st, it reported that YouTube had denied the retraction request, because the retraction notice was not sent from the same email that had issued the initial fraudulent takedown notice. Bing, bing, bing. That's where the problem is. If you're the company, you can't fix the takedown notice because you didn't issue the takedown notice. So this is a system issue with regard to YouTube's DMCA system. So now we're going to have to figure out how this system gets fixed so legitimate companies don't get spoofed like this. In the interim, the nature of Doe defendants' impersonation of Bungie had become clear, and Bungie had reached out to YouTube to try to address the issue. On Saturday, March 19th, under the direction of Bungie's legal team, it sounds like Bungie's legal team was working literally overtime. On Saturday, March 19th, under the direction of Bungie's legal team, Bungie's social media manager reached out to the account representative for Bungie's YouTube channel, Walker Adamson, to report that they had seen a number of additional users and their own channel get hit with takedowns from a quote unquote Bungie Inc. Bungie also informed Adamson it had confirmed that it was a malicious impersonator and asked for Google's assistance identifying Doe defendants and next steps to prevent the attack from continuing to occur. The good thing for Bungie, the bad thing for the people who did this, but the good thing for Bungie is that their own channel being hit gives them more access to more information on the back end because it happened to their channel too. And I'm sure the creators who this happened to will be like, hey, I will cooperate. But because it happened also to a channel that they control, they're going to have a little more ease of getting some of this information. So this is all going down on a Saturday. Lawyers, do you work weekends? Oh, when do lawyers not work? Never. 10 minutes later, after receiving an out of the office notification from Mr. Adamson, Bungie's social media manager passed the same message along to Magali Hut, Google's head of games publishers. And if I pronounce that badly, I don't know how to pronounce hot. We're going to go with Magali Hot. Magali Hot. Google's head of games publishers. And the person that the out of office message identified as having available to help while account representative Adamson was out. An hour later, having received no response, Mr. Barker added Bungie's legal department to the email conversation and CC'd Bungie's general counsel, indicating how serious of an issue the attack was for Bungie, providing detail on Bungie's legitimate takedown notices, and asking Google to provide information on the Doe defendants. Mr. Barker also instructed Google to block any new DMCA reports that purported to be on Bungie's behalf until further notice. I wonder if they did. Let's keep reading. Upon information and belief, Google did none of these things. Oh boy. Thus, on Sunday, March 20th, having received no response, well, it's Sunday, Barker emailed Hot to note the situation was escalating and that a number of trusted streamers, including My Name is Biff and Aztec Cross, were receiving fraudulent takedown notices. I mean, I imagine the stress was real for the Destiny streaming community, because once your channel gets hit with 3, you're down, and you could be down for a week or more with nothing that you can do to fix it. You can lose your channel with nothing you can do to fix it. As a content creator, I'm sitting here going, oh, I can feel the stress that this situation would cause when the company is telling its creators, we're trying. And the creators are like, but bro, stop it. And Google is not responding. How do you stop it from happening? Like, the shit's already out of the horse at that point. Barker asked Hot for a response as soon as possible. Information on how the Doe defendants were able to so easily impersonate Bungie, and most importantly, information on what YouTube could, quote, do to begin mitigating the damage done to our community of streamers. Barker also asked for a more reliable way to contact someone at YouTube to handle exigent issues like this one. Fair. Roughly 40 minutes later, having still received no response, it was the turn of Bungie's global franchise director to try to get some sort of a response from Google regarding the spiraling problem. Thus, at 2:08 Pacific, Bungie's global finance director emailed additional Google personnel, all named here, to reiterate that Bungie had, quote, a corporate impersonator who is doing damage to some of our trusted community streamers on YouTube, and that Bungie was looking to connect with someone who could assist and specifically introduce Barker to the Google team. He needs access to the Google legal team, which he probably now has. Mr. Barker also reiterated Bungie's request that Google, 1, block new takedowns, 2, restore any takedowns process after March 16th, and 3, obtain and provide information on the Doe defendants. Ms. Johnson, YouTube's director of gaming, publishers, and commerce content partners, responded to ask whether the issue was that Bungie's channel had been compromised or only that it was being impersonated as a part of the DMCA takedowns, and whether Bungie had gone through standard channels and filed a help ticket. Oh my God, can you imagine? Can you imagine going through all of this and having somebody be like, "Did you file a help ticket?" Can you imagine how you would respond? You would be like, "Are you fucking kidding me? Did I file a help ticket? Stop this from happening." Uh, literally the expletives that would happen when someone read that email. When someone read that email, oh, just it it would literally mind-boggling. I would lose my mind. I would lose my mind if I was the lawyer dealing this. Have you filed a help ticket? Yes, we filed a fucking help ticket. Here's a whole list of everything that we have done. A help ticket. A help ticket isn't going to get us there. What the fuck? Barker replied, probably not the way I just did. Barker replied that the issue was simply the DMCA related impersonation and that YouTube's opaque support process was running them through a circular loop from hell. No, that's not true. A circular loop from contact us back to the help community. Yep. They were running through a circular hell of trying to get an answer. Johnson responded that she would connect with YouTube's takedown notice team and report back. On Monday, the 21st, Hott responded to Barker's email about the, quote, escalating situation to apologize for the delay and note she was looping back in with Adamson and that they would get back to Bungie quickly as possible that day. At 11, well, at least eventually it got addressed to someone. The help ticket maybe did it. At 11 a.m., Barker reached out to Adamson and Hott and update them on some of the developments discussed in more detail below. That Bungie had identified the Jeremy Wild CSC as the email address responsible for at least some of the takedown notices, and this other one, Damian Reynolds CSC, as having sent taunting and threatening emails directly to CSC. Barker reiterated that the only people authorized to issue the DMCA notices on YouTube were CSC and provided the two legitimate addresses. At 5:29 p.m., Barker emailed Adamson to note that he was looking forward to any updates. Oh, I'm sure. He's like, anything. Bungie still had no way to tell how many may have been issued, but had not yet been brought to Bungie's attention through social media. At 8:09 p.m. that day, David from YouTube's gaming support team responded that YouTube did not have an update yet, but that it should be able to provide one by Tuesday the 22nd. On Tuesday the 22nd at 1:17 p.m., having not received the promised update, Mr. Barker again asked Google to speed up its response and provide critical information. We need a couple of things urgently in order to mitigate the harm to our community. A list of the channels and uploads that were actioned by the two users who use the fraudulent email addresses so that we can request reinstatement, a list of all channels and uploads that have been actioned purportedly on behalf of Bungie Inc. and the email addresses attached. What are you able to do in order to make sure that takedowns on YouTube that are, quote, on behalf of Bungie Inc. are only an approved set of email addresses? What are you able to provide about the identities of the users who have actioned on behalf of Bungie Inc., as those threat actors are causing active harm to CSC's reputation and to ours, and have threatened employees at CSC. It'd be interesting if YouTube implements a checks and balances where companies can say, hey, or I as a creator could say, hey, if I'm issuing takedowns, they're only coming from these emails. I don't think it would be hard to put that in the back end and say, if I'm issuing takedowns for my content, it's only coming from these authorized email addresses. No one else can issue a takedown on behalf of my content. It doesn't mean no one else can take aim at me saying, okay, I'm taking this down. You used a song, you used whatever. But it means that if I'm taking down content, that I can provide the authorized emails in the back end of Creator Studios. It seemed like that maybe wouldn't be a hard checks and balances system. But maybe that's just me. Maybe that's too simple. But it seems like you should be able to just do that, and you would just turn it on in the back of YouTube Studio, and then you could let not the algorithm, but you could let machine learning check those and be like, oh, is this from an authorized email? No? Okay, then you can't issue it. Like, why is that hard? I don't know. It seems like that should not be that hard to do. At 3:18 p.m. on March 22nd, Google provided an update. It had terminated the accounts that submitted the fraudulent request on all fraudulent submissions, and all fraudulent submissions would be reversed. but Google would not share any information identifying who the fraudulent users were, including channel identifiers, email addresses, or other identifying information without a law enforcement request or civil process. Well, that's why we're here. That's why we're here. That's why we're here. A Haunted Shadows legacy is like, yeah, that'd be super duper easy to implement. I would think so. And each channel creator would be responsible for putting that information in their back end of their channel. Well, that's why we're here. Google's not going to give them anything, and I'm not surprised by that. Google's not going to give them anything without civil process. That's why we're here. Fortunately for those people whose videos were targeted by the fraudulent takedown notices, Bungie has the financial resources to begin the civil process in order to meet Google's requirements. Doe defendant's confession and harassment of CSC. Ooh, fascinating. Fascinating. Well, Bungie's legal department, management, and executives were attempting to negotiate the Byzantine procedural labyrinth. Wow. The lawyers are riled. It was, you know what it was? It was the, did you issue a help ticket? That's what riled the lawyers. That was the moment that the lawyers were like, oh, fucking hell. It was the help ticket. That's what it was that riled the lawyers. That's why the lawyers are riled. The Byzantine procedural labyrinth Google required before it would address the fraud its users were committing, let alone identify who its fraudsters were. Doe defendants themselves were gloating, confessing, and threatening. Over the weekend, the Damon Reynolds account began sending threatening emails to CSC with the subject line, "You're in for it now," and telling CSC better start running, the clock is ticking. At 12:41 a.m. on Monday the 21st, quote unquote, Damon Reynolds emailed David Thompson, CSC at Gmail, the following. Oh, I wonder if the reason that they suspect it's from people who had legitimate takedown notices issued against them is because they had that email address that they wouldn't have otherwise had access to. I mean, unless it's on Reddit and things, but unless that they wouldn't really have access to unless they had received a notice. I wonder if that's why they're connecting that dot that way. So they emailed the David Thompson CSC Gmail the following. Hope striking everyone's content was worth it, asshat. You've now got Bungie's full attention. You really ought to grow up and get a life instead of tormenting people from behind a screen like a fucking coward. If I were you, I'd delete my Google account right now because Bungie and probably even Google are going to come after you hard. Well, that's kind of juvenile. However, did they not realize that this was a company hired by Bungie? Maybe they just weren't aware. Maybe they just weren't aware. Meanwhile, two YouTubers, Aussie Halo and Bresci, were each forwarded Bungie's community team an email purporting to be from Jeremy Weiland's account taking credit for the fraud. Quote, the manifesto. There's a manifesto? A manifesto is almost as good as a murderous conspiracy. I am here for a manifesto. Let's manifesto. The manifesto reads like a hackneyed "look what you made me do" letter from the serial killer in a bad novel. It is a murderous conspiracy. It is. Oh boy. Let us manifesto. Greetings. I am one of the people who filed false takedowns on videos uploaded by you and others in the Destiny community. The other person filing takedowns is David Thompson, CSC at Gmail. Oh, the legitimate one. Whom I will refer to as David Thompson. I am not aware of any other email addresses that are being used to issue fraudulent takedowns. I am also keeping some parts of this email confidential for obvious reasons. With that said, there's more to this that you should know. One, as is obvious, I'm not employed by CSC and I have no affiliation with Bungie. The same applies to David Thompson. Two, YouTube's copyright takedown system is incredibly flawed. I mean, they're not wrong there. Their verification system for takedown requests is so gullible that people such as I and David Thompson are able to file takedowns without any legitimacy to our names. If you're looking to place blame, place it on YouTube for its sloppy copyright takedown system and Bungie for ignoring this issue for so long. I could tell you how I got YouTube to think I was a legitimate representation for Bungie. All it took was a single sentence: no documents, no license, no private information. Also, I did not issue takedowns on Bungie's own channels. Whoever did that is further proof that YouTube doesn't verify the identities of takedown claimants. I was directly affected by false takedowns from David Thompson. Oh, another reason that they think it's connected, because they fucking say it is. Wow. I was directly affected by the false takedowns from David Thompson several months ago, and many others were issued false takedowns by this person over the past several years. I believed with enough attention, Bungie might have been prompted to step in. The first few channels that were hit by takedowns didn't seem to grab anyone's attention, so I had to escalate the matter. If I hadn't escalated this issue, many people would not have had their takedowns removed. Okay. Oh, it keeps going. You may choose not to believe me, but at least I responded to some of the people whose videos I took down. The other frauds, like David Thompson, never reply because they're spiteful cowards who want their victims to feel helpless and afraid. David Thompson has also been issuing false takedowns for years with no repercussions. Although, unlike me, they have been playing it safe up until now by only issuing takedowns on a few videos to avoid Bungie's radar. I intended to get caught so that Bungie would take heed of the corruption that has been ensuing in the center of their YouTube community. Well, why don't you provide a name and IP address, and then you can get fully caught and sued. I fully intend to retract my takedowns and stop issuing them after Bungie had acknowledged the issue and began restoring people's videos or channels or otherwise. Except that they fucking can't, but they fucking can't because they don't have the email address that issued the takedown. So except for that, if David Thompson went after more videos, I wouldn't be able to remove the takedowns since takedowns can only be retracted from the original claimant's email address. Oh, there it is. There it is. We acknowledge. Keep reading, Emily. Otherwise, I would have undone all of their actions and prevented this altogether. None of this was about copyright infringement, nor did it have anything to do with the Sony acquisition. Oh, there's the Sony acquisition. In the future, you should expect the claimant's email address in the quote contact info field of the copyright takedown notice made on behalf of a large studio like Bungie to originate from a domain other than Gmail when determining its legitimacy. Except that you can't, because you have to have a Gmail address to issue a takedown. Except that you can't. Oh my God. When does this become a Lifetime movie? Drama in the gaming community. All right, I've got to finish this. Finally, I know this hardly means anything, but I apologize to you and everyone else who was affected by my selfish actions. What the fuck is happening? You have every right to be furious with me. My goal was to get Bungie to see the fake takedowns and stop them. That's all. Well, Bungie is stopping your fake takedowns, bruh. But the David Thompson takedowns are legitimate. And you just seem really pissed off about it. I'm fascinated. I'm fascinated. I want to know so much more about this. I want to know so much more about the drama in the gaming community, because this is some high level drama. This is a like mustache twirling cartoon villain. Sammy Oak said, I'm waiting for the villain origin story. Same. Hopefully it'll be on Reddit or Twitter, and we'll get to see. Wow. All right. First cause of action, DMCA fraudulent notice. Yeah, it's illegal. Bungie holds the copyrights to their games. Bungie holds 200 copyright registrations, which means they hold the copyright to their games. Bungie did not authorize the takedowns. You can't do that. Second cause of action, false designation of origin. They put in that they were Bungie. They said it was Bungie Inc., falsely designating the origin of the takedown notices. So that's count 2. Third cause of action, copyright infringement under 17 USC 501. Bungie holds more than 200 copyright registrations, while Bungie is not aware of the specific content alleged in each of the fraudulent takedown notices to have been infringed. Upon information and belief, alleged infringement was an what? Upon information and belief, each alleged infringement was an alleged infringement of content for which Bungie has registered the copyright. By submitting the fraudulent takedown notices, Doe defendants infringed Bungie's rights under 17 USC 106 to authorize the public display and performance of its copyrighted works. Oh, that's an interesting theory. The infringement was willful and evidenced by the manifesto. Wow. As such, Bungie is entitled to damages and injunctive relief, including enhanced statutory damages of $150,000 for each fraudulent takedown notice. Wonder how many were issued. Can't wait till that comes in. That could get pricey real quick. That could get into the millions real quick. In addition, under information and belief, in or about March 2022, content uploaded to YouTube by one or more of the Doe defendants was subject to DMCA takedown notices submitted on Bungie's behalf. So this theory under the copyright infringement is that they are infringing the copyright by blocking it from being up by issuing the fake takedowns. That's an interesting theory. Bungie should make a boss character in a future expansion of the manifesto or the manifesto writer. All right. Let's see. Fourth cause of action, business defamation. Interesting. Doe defendants made the false claim with actual knowledge of its falsity. Well, what was the false claim? Doe defendants' fraudulent takedown notice included the false claim that the fraudulent takedown notice were submitted either by or on behalf and with the authorization of Bungie. Defendants made the false claim with the knowledge of its falsity. Yes. Defendants made the false claim with actual knowledge that in implementing the DMCA takedown, YouTube would pass along that false assertion to the targeted YouTubers. Upon information and belief, Doe defendants made the false claim with the intent that the targeted YouTubers would report to their subscribers, followers, and friends that Bungie had taken down their videos. Interesting theory of defamation. Upon information and belief, Doe defendants intent was to cause anger and consternation at Bungie with the Destiny community so as to, quote, get Bungie's attention and or stop Bungie from sending future legitimate takedown notices. This intention and malicious conduct resulted in harm to Bungie's reputation. That's an interesting theory of defamation, but I see it. It's you were willful, you knew what you were doing, you knew it was fake, and the intent was to get the attention as stated in the manifesto, and doing that hurt the business reputation. Huh. Interesting. Lynn, as I said at the beginning, Bungie is a game developer for Destiny, Halo, and other video games. So they're the development company now owned apparently by Sony. Interesting theory of defamation. I like this lawsuit very much. Fifth cause of action, violation of the Washington Consumer Protection Act, which we also saw, I believe, in the Toddy Westbrook, Washington first defamation case. Doe defendants have engaged in unfair and deceptive acts by fraudulently impersonating Bungie to issue false takedown notices because they put Bungie Inc. in the takedown. Doe defendants' practices occurred in trade or commerce. Fair. As alleged in the complaint or the counts of this complaint, Doe defendants' actions were unlawful. Moreover, Doe defendants' manifesto, in effect, is calculated to discredit the authenticity of takedown notices legitimately issued by Bungie's authorized brand protection personnel. The manifesto has already resulted in confusion among the creator community, causing at least one recipient of a legitimate copyright notice to file a copyright counter notice on the improper basis that the authorized brand protection agent was otherwise. Moreover, there is a strong public interest in protecting creators and businesses from bad actors impersonating and misrepresenting them in the marketplace. Sixth cause of action, breach of contract. Bungie repeats and alleges all the stuff above. The LSLA is a valid binding contract between Bungie and each individual player of Destiny 2. Destiny 2 cannot be played unless the user agrees to Bungie's LSLA. The LSLA is displayed in full of the adhesion contract user agreement for the user in the game client prior to the user's first play. The LSLA is also made easily and readily available on Bungie's website. Upon information and belief based on the fact that Doe defendants uploaded videos that contained content infringing on Bungie's copyrights and therefore must have played Destiny 2, Doe defendants agreed to the LSLA, which prohibits them from copying, reproducing, distributing, displaying, using any part of Destiny 2, except as expressly authorized. The defendant's display and use of Destiny 2 to create content that was subject to a valid takedown request was not expressly authorized by Bungie. Bungie is entitled to damages for that breach of contract. Of all the claims, that one feels a little petty, but that's okay. Throw it all in there, and we'll see what happens. Damages in an amount proven at trial, preliminary and permanent injunctive relief, barring defendants and anyone acting in concert with them from impersonating Bungie, cost attorneys' fees, etc. Well, they are going to have to find the infringers first. So those are the rest of the filing notices. They are going to have to find the infringers first, and they are going, which is why we now have the subpoenas being issued to Google saying, you need to show us who this is. I can't imagine Google's going to fight them on these subpoenas, motion to quash, etc. They're going to, I imagine Google is going to cooperate with these subpoenas after the mess that is creating and after the slamming that YouTube has taken in this complaint. I can't imagine that legal at YouTube won't cooperate with these subpoenas easily and quickly, and I hope they do, because it's in YouTube's best interest to protect its creators on its platform, but also protect the companies that make the content that creators use on their platform, because I'm sure the Destiny community has millions, tens of millions plus views a month that are being monetized, and YouTube gets a portion of all of that monetization. So it's in YouTube's best interest to actually fix this system. This is a fascinating lawsuit. We are in for this one. This one's getting permanently added to the docket, and we are in for a ride. I want to see who they find a name in this lawsuit now that they've issued subpoenas. I want to see how the court deals with the lawsuit against Doe defendants, because it's a very chicken and egg. By the way, Cadbury cream eggs are back for the holidays. I haven't gotten any yet, but I'm very excited. Every time I see egg, I think of it. But it's a very chicken and the egg situation. Google won't give them the information of who the Doe defendants are without legal process. You can't initiate legal process without initiating a lawsuit. And it's just again, a circular problem. So they initiated the lawsuit. They have 90 days to find who this is or whom this is that has issued these takedown notices. I wonder if the individuals who did this are worried. I wonder if the individuals who did this are worried. I wonder if they care. I wonder if they'll contact Bungie and be like, yo, we just wanted your attention. Like, calm the fuck down. No need to sue us. Like, let's just resolve this. Please don't fine us $150,000 per takedown issued. But it's a warning to those who file fraudulent takedown notices. And I think YouTube is going to have to fix that system and deal with those who file fraudulent copyright strike notices and copyright takedown notices and falsely flag channels. Falsely flagging channels is also against YouTube's terms of service and should result in permabans. And I am not going to walk that back. If you are abusing YouTube's internal systems, then you should be banned off the platform, because it makes it harder for the system to work the way that it should. It's already a push-pull with intellectual property. So people who abuse YouTube's own terms of service, YouTube needs to enforce that. YouTube doesn't stringently enforce that. So with that, I have questions. You have questions. We have a lot of super chats. We're absolutely going to go for it. Some people are going to be like, are you calling for deplatforming people? No, I'm not. I'm calling for YouTube to enforce their property, their policies. And if people are repeat offenders that are abusing the takedown system, they should be yeeted, because it's a dick move. And you now see the circular issue where creators can lose their channels without fixing it. This has happened to Eric Hunley. I know it happened to Uncivil Law. It's happened to others when their channels get hacked and people put up content that's against community guidelines, that YouTube can yeet channels for community guideline strikes. We've seen attacks on Ethan Klein's channel. We've seen attacks on other channels. So when you are maliciously and inappropriately using the systems, the reporting systems on YouTube in violation of YouTube's own terms of service, YouTube should actually enforce it. And they don't do that quite a lot, but they should. All right. I've got questions. You've got questions. We've got questions. Let's get to questions and super chats. And then I am going to get out of here and go get some lunch. I know it's another long one. Y'all are like, do we do 3-hour streams now? I don't know. I talk a lot. Sometimes. Thank you, moderators. You guys go ahead and give the love to the moderators. Not always easy topics today. And it can get a little polarizing. I hope it didn't. The mods will let me know who misbehaved. But thank you, mods. I have questions. You have questions. We have questions. I'm going to get to questions and super chats. It won't just all be super chats. It won't just all be questions. We'll do both. So for those of you that super chatted earlier, I try to get to those at the end. So, yep. Thank you. Thank you, Kersey Nurse, for doing the math that it's 750,000 just from the takedown notices named. I'm sure there's plenty more and that US can find them. Bungie wants the fake names, suing the John Does to get subpoenas from Google. Yep, that's a great explanation of that. Emily, Kavanaugh opposition to the slap filed yesterday, only 400 pages this time. We'll get to it on Friday. I haven't looked. I'm sure I knew the opposition was coming due, but we will absolutely get to it on Friday. If it is super tea-filled, maybe I'll do it. Maybe I'll do an early one because Friday, hold on. I need to look at my calendar because there's also a hearing on Friday that I'm very interested in that we'll cover. I think we can cover both, but I'll have to preview that because 400 pages, we're not going to go through all of it. So I'll do a preview on it. Let me see. Checking my calendar. Oh, Friday's April Fool's Day. That's a perfect day to cover Kavanaugh. And yeah, there's a court hearing on Friday that I'm going to be attending and covering on Friday night. So Friday night is already booked. Okay, law things, law universe. I need you to just pause. I need you to just law universe. We're already booked for Friday. We're booked and busy. We're booked and busy for Friday. Oh, we're booked and busy. Okay, let's get to, you guys just put questions at the beginning as the mods say, and as the mods remind you. Guys, thank you for the love for the mods in the chat. So this lawsuit is about fake takedowns and their does, and someone wants their real names, love 3-hour streams. To summarize the Bungie lawsuit, they are alleging people maliciously use the takedown system on YouTube to damage their company. It's illegal to file false DCMA notices under the US code. It's illegal to say that you are representing a company and you're not in this context. So that's the false designation. And then copyright infringement and defamation. So Bungie is saying that others pretended to be Bungie to issue these takedowns and they were damaged in this way. They filed it as does because Google will not give them the information without legal process like a subpoena, but you can't just issue a subpoena without a court case it's attached to. So they filed this lawsuit to Google subpoena so they get the names of the people to sue and then they will go from there. So let's us continue. But that was a good question. Hopefully that summary worked. Very interesting. Very, very interesting. All right, getting to some of the earliest super chats and super stickers. Andrea, thank you. Sarah said, I made a live finally. Yay. Just a little something to say thank you for all you do and the mods. And the Fred and George, love to all. Thank you so much. I mean, if we've got 400 pages to buy, your super chats fund my legal research. Classy Mom, good to see you. I just wanted to say how much I love the channel and all the law nerds. Having to take a little mod break with new grandbaby coming soon. Congratulations. So honored to have been a part of the road to 200K and still plan on being around. Thank you, Classy Mom. We appreciate you. Aaron Evans said, I'm so excited to see your take on Bungie. I'm an avid Destiny 2 player, and these takedowns have been a whole thing in the community, and we all have questions, so many questions. Well, hopefully, Aaron, if you're still in the chat, let me know if the questions were answered. Hopefully they are. And I cannot wait to go onto Reddit and see what the community's been saying about it. It's not a community I'm familiar with. I love gaming. I love game communities. I wish I had a gaming channel and I had an excuse to game more. I'm not good. Megan B said, love you so much, Emily. Mad respect. Thank you. IMO, this is staged to distract us from the great reset agenda of 2030, which is staged. I'm assuming the Grammys. Okay. Miss Opinionated said, hey, Emily, I have a legal question from last episodes of Secrets of a Playboy. I've not seen it. Any chance you'll watch it? Sure. Twins mentioned a lot of manipulation. One love. Miss Opinionated, I have not seen it at all. I haven't even gotten to watch Bridgerton yet because I still have stuff I need to do with regard to the Tinder Swindler and the and Anna Delvey from Inventing Anna. Plus, I have a whole breakdown for next week as we're getting ready to start trial in the Depp Heard case. So yes, Jess Matt said knitting copyright is a weirdly contentious issue. Oh, Jess, I've represented knitting creators who created patterns and the theft of patterns and the reuse of patterns. It's a whole thing. It's not oddly contentious. There's a lot of money to be made in copyright in knitting and cross-stitching. The craft community can be very cutthroat. The drama within the little insular communities of different crafts is fascinating to me. I always want to hear it. When somebody's like, oh my God, there's drama in the wreath community, I'm like, I'm here for this conversation. Question, say SCOTUS finds fair use, but Campbell's sues for trademark use or TM use, copyright use. Would the TM suit be any different than this copyright one? Zoe, I need to look and see if there was ever a lawsuit from Campbell's because I don't remember if there was or if there wasn't with regard to Warhol works and with regard to whether it's copyright infringement or trademark infringement. Trademark infringement is different than copyright infringement. Copyright infringement has this aspect of fair use and transformative use, different than trademark infringement. So that's a hard question to answer because this is about copyright, not trademark. But if it's clearly fair use, I don't know why Campbell's would sue after, but I need to look and see if there weren't any. So, Maddie, hi, you're great. Thank you. The services aren't free. I had to pay like $40 to file even the basic form. That is regarding our earlier conversation of TurboTax. Elise Nicole said in 2018, I qualified for file free. TurboTax forced me to pay $120 upgrade so I could file a Schedule C because I was a 1099 worker. See, it's like, and this is what the FTC is saying. This is what the FTC is alleging. Ashley said, I've never been able to file using TurboTax for free. I've always considered it a bait and switch. They always make sure you need, quote, additional forms. And that's what the FTC is alleging. The liability you take on when you complete your own taxes is also free. The tax fuckery is real. Kathy, for sure. For sure. Avaloma said, the police are dusting Chris Rock's face for Fresh Prince of Bel-Air. Sorry, my best mom joke. I mean, we've seen a lot of the memes. The memes came in fast. The memes on that came in very, very quickly. And there were a lot of the rock beats or paper beats rock and stuff like that. So, oh my. Question, if you work for a company, do you still have to file your own taxes in the USA? This is so confusing. Oh, yes. Your company gives you the tax forms, but you still have to file your personal tax forms. And in the US, you have to file state tax forms in most states and then federal tax forms. We have dual systems of government and you have to do both. It's crazy. Totally off topic, but I got my first Green Chef box today looking to see if it's better than its sister company. So far, so good. I love Green Chef, but you know how happy I've been with them absolutely with them being a wonderful and welcome sponsor on the channel because also food. Thank you, Emily. Thank you for your thoughts, Emily. You're welcome. You're welcome. You're welcome. So what is an attempted assault? Hansel. Well, generally the legal definition, like the black and white legal definition of assault becomes an attempted battery. In most states, an attempted assault is one that's not completed with a battery touching, but it depends on how the state law defines the attempt of an assault. And normally you file the assault and then there's an attempt statute, but it depends on the state. So an assault is generally an attempted battery, but most states have an attempted assault, but it depends on if they charge it or not because the assault is complete with the anticipation. So it just depends on how the state laws are written. Tiffany Lesson said Supreme Court equals circuit breaker. Exactly that. Carla said the Oscars has, quote, set a precedent in how they've handled physical violence. How do you think this will affect, future physical issues at the Oscars? Hopefully there won't be any, and this was a one-off. I think presenters will be much more mindful if somebody starts taking the stage, and I think that the show will be much more mindful if people start taking the stage when it's not their time to take the stage, to prevent that from happening, because it puts the person on stage in a really awkward position to do what? And we saw that with Taylor Swift freezing when Kanye took the stage. She was like, I don't even know what's happening right now. And how do you intercede that other than cut someone off from getting onto the stage? Andrea said, I feel like that had more to do with her entanglement. In Will's book, he said that he wished he was more like Tupac. Jada has Will all messed up. I've not read Jada's book, but thank you for sharing your comment. Subway Surfer said, what happens for A and B without witnesses, pics of bruise, etc.? A and B are, I'm not sure who we're talking about with A and B. I'm sorry. Without witnesses, pics of bruises. I don't know what we mean by A and B. Assault and battery. Ha. What happens with assault and battery? Thank you. Without pictures or witnesses of bruises, it depends on the jurisdiction. A lot of the time, and again, it depends on jurisdiction. A lot of the time, if there is no corroborating evidence, they become very difficult to file. You need the person complaining of the thing and then corroboration of the thing. That can come in a lot of different ways. Without pictures, you can have text messages that indicate it, conversations, other things, but you need some form of corroboration for a filing in best practices. So those types of filing decisions are made on an agency by agency basis. Ashley Vincent, can we hold comedians to a standard where disability and health are considered poor taste? I mean, I think it is. Even for them, as a disabled Black woman myself, I'd like to feel safe at a comedy club. Ashley, I absolutely hear you. That is not like taking shots at people's bodies and what they look like, and that's never been funny for me. I also think it's kind of a low form of comedy that doesn't take a lot of effort. I tend to not go to comedy clubs either, unless it's somebody that I know and like, and that I know that they're doing the type of comedy that I follow, where it's like teacher comedy and stuff like. The amount of teacher comedians that I follow on Instagram and TikTok is ridiculous because I think it's hilarious. I like observational comedy more than comedy targeted at people's health. I don't know how we change the nature of comedy in a world where free speech, just because something is distasteful and offensive, it's still free speech. But I think it's a conversation that's been opened up, and I hope that the conversation continues, because the conversation should continue. So thank you, Ashley, for that. I appreciate your thoughts. Brandis Bedazzled said, I used to do video game marketing and PR. The amount of free codes we sent to streamers relying on that form of advertising. Oh, I don't doubt it. My kid is like, no, I want my avatar to look like Tico. Speaking of streamers with voices, I cannot. I want this to do this. I want that to do that. It's very, very informative. I get so easily swayed. I am not proud of this at all. I am not proud of this at all. This is just what it is. It's just the truth. Here's the truth. I was and I meant to tell this story on another live stream, and then my mind yeeted. It might have been during the behind the scenes filming of the podcast, but I was sitting down watching the latest episode of The Dropout on Hulu, which I love. And they were showing a scene with the attorney who was supposed to be, or the person portraying the attorney that was David Boyce. And he's sitting there eating like a bowl of Cheez-Its. And I'm sitting here going, oh my God, I totally want Cheez-Its. Cheez-Its sounds so good. We have no Cheez-Its. And was like hyper fixated on the fact that I needed to have Cheez-Its in my house. My kids have now since eaten all of them. And even as I bring it up now, I'm like, oh my God, Cheez-Its sounds so good. I want Cheez-Its. But that is that is the level of susceptibility I am when it comes to marketing. So this works. I was like, I want Cheez-Its. I want Cheez-Its. Highly susceptible to marketing, and it does work. I watched somebody talk about their best travel tips, and I'm like, oh, I totally need a new travel backpack. No, I don't. No, I don't. Hazel is just trying to make sure I get demonetized. Testing. Susan did something else. Hello from Nottingham, UK. Love your channel. Even though UK and US laws aren't the same, it's still so interesting and entertaining. Thank you. I try to make it interesting and entertaining. I'm sure someone can make this lawsuit boring. I don't know. I don't know if they could. Susie said, I like Rodney Dangerfield. He mostly made fun of himself. Exactly. People are eating Cheez-Its now. I am, I also like comedians like Jim Gaffigan who make fun of, like, talk about food and observational comedy, and again talk about themselves. It you know, it can be funny. There's lots that can be funny. Are you guys talking about just notified that Hilaria Baldwin is pregnant with number 7? Some Duggar level stuff right there. The timing of that is interesting to me. That's interesting to me. That's interesting to me. That's interesting to me. So everybody's like grabbing Cheez-Its now. You're welcome. Highly susceptible. There was a night when I was pregnant with Travis that we were like, an ad came on TV for Twizzlers. I'm normally a Red Vine girl, not a Twizzlers girl. And I was looking at it going, Twizzlers? I need Twizzlers now. My husband's like, what's happening? I'm like, nothing has ever sounded better right in this moment than Twizzlers. Now I need them. Like, it was, the susceptibility is real. The susceptibility is real. Okay, now I've got to go to Twitter and see about Alec Baldwin and baby, because now I'm very confused. Oh, there's fighting happening in the chat. This might end up on Friday Night Live. This might have to be on Friday Night Live. Cheez-Its versus Goldfish. I think that's it. I'm so triggered. I will ask Dr. B about Twizzlers. Hey, NJ, good to see you. I don't know if he'll even remember. He might. I need to find out. Oh, this comment. I'm sorry. I just got onto Twitter and I saw this comment from Natalie Lawyer Chick, who said, someone asked me, why aren't you smiling, beautiful? On my way into court yesterday, I was wearing a mask. Stop telling women they have to smile. Stop telling women they have to smile. Women don't have to. Stop it. Stop it. I hate it so much. That happened to me so much in court. It's like, you look so pretty when you're smiling. It's like, I am here to rage. I am not here to smile. Did you see Alec Baldwin's IG post about the Oscar thing? Irony was strong there about producer responsibility. I didn't see Alec Baldwin's Instagram post. Now we're just social media exploring real quick because I didn't see it. Thank you for bringing it up, Lynn. Let's go look right now. Let's see. Let's see if it was a story or a post. We're just going to pull it up and see. Let's see. It must be this. Heartfelt congratulations to Questlove. Wait, why is this not pulling up? Heartfelt congratulations to Questlove. May this be the inspiration for more film work for you. I'm so glad, Questlove. One, I am not reading much about how or even if the producers attended to Chris, but I love you at Chris Rock. I'm sorry the Oscars turned into the Jerry Springer show. Okay. Okay. A repost from my wife, Hilaria Baldwin. After many ups and downs over the past few years, we have an exciting up and a huge surprise. Another Baldwinito is coming in the fall. I guess that's the baby announcement. We're pretty sure our family was complete and we're beyond happy with this surprise. I'm sharing with you the moment we told the kids. As you can see, they are super excited. Our new baby is a very bright spot in our lives, a blessing and a gift during such uncertain times. I've missed you during my break from social media. I'm back and looking forward to continuing with you this wild journey we call life. Our love to you and your loved ones. Interesting. There we go. Baldwin, I just recall that well, we've all seen the Rust lawsuits. We've seen the Rust lawsuits. We know how Baldwin has acted as a producer. So interesting. We might have to do Cheez-Its versus. The kids low-key don't look excited. I mean, it's a lot of kids, but my family is complete at 2. So it's a lot of kids. And Anyone tried the new Cheez-Its that are puffy? Yeah, I like them, but not as much as the original. That's my answer. I'm sure the chat has other answers. Chat, answer away. All right. It has been over 3 hours. I think we got to all the super chats. If I missed one, I am sorry. I am sorry. I am sorry. I tried. I am going to link Natalie Lawyer Chick's video, and I will link the other things I've mentioned if I remember. I always try to do my best, and I will link stuff. And as the comments inevitably point out, did you link this? I will go back and link it. So anyway, look for Jim Carrey's reaction. I will look for Jim Carrey's reaction. I'm not surprised. Holly, I didn't forget to post the Fred pics. I posted them on my Insta stories. They were up there. I can repost them, but they were up there. JC's getting controversial in the chat, man. Getting controversial in the chat. Can't stand goldfish or Cheez-Its. I don't know. So with that, it is time to say goodbye. Another huge thank you to the mods. Timestamps will be up shortly once I get them up. I will absolutely be posting everything. I might have to go get some Cheez-Its for lunch. Like, it's just going to be. I appreciate you. Thank you for being here. Thank you for being a law nerd. Don't forget to do the likey, subscribey things. And we will be talking more about these lawsuits in the weeks to come. Cheers. Have a good one. Bye. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.